Hi, Miss Anna.
All right, can you hear me?
I can hear you.
All right, so I have another, if you have a break in the, like for like lunch break, then I have another, I can post something similar and I put the time when you're going to resume the hearing.
Okay. Who do we have for our court reporter this morning?
It says it's Kendra, but I think it might be Melissa. I cannot.
Okay.
Oh, it's Melissa.
It is Melissa. Hi, Melissa.
Hi, how are you?
How are you?
Good.
I'm well.
Hey, nice to see you.
Nice to see you
Good. Good
too.
to see you. Are you at home?
I am.
Yeah.
I'm trying to change my name, but it is not going to let me. See.
A
Nope.
ver.
Maybe you can change my
How
name.
do you spell your last name?
Goodson, Goodson.
Do. Okay, well, I guess people are
That
waiting.
looks better. I hope I didn't
Yeah,
misspell it.
that's me.
Oh,
Thank you.
yes.
All right.
Yay. Thank you, Anna.
So I did not receive any requests for public comment.
Okay.
And I don't know, you want me to hang around until you finish or what do you want me to do?
Let's keep you on at least until we have everyone on.
Mhm.
And then maybe you can go away and check and make sure our YouTube is working. Excuse me. And then other than assisting with the exhibits,
Mhm.
I think you can, we have them all ready to go unless they're changed. So I don't think you need to hang around if you have other stuff you want to do. Okay.
There's all thing, Madam Hearing Examiner, if I may. I was just visiting with Joan Drake on the phone, and she was having a little difficulty getting on. And so I think she's currently trying to figure it out. Failing that, I used the call-in number, but she was having a little trouble with the Zoom.
Okay,
yes,
she did
numbers
not.
are in the link.
I'm sorry, what?
The phone numbers that you can call are
Yes.
in the link with the hearing examiner sent with the Zoom meeting. There are phone numbers there that you can call.
Okay. She
I just admitted her.
There she is. That's great. Thank you.
So I think other than our pro se people, excuse me, I don't know how to cough with a microphone. Like, okay, what do you, oh, no, there's our receiver. Hello, Mr. Lewis.
Good morning.
So the only ones I don't see yet are the interveners. Did anybody get any indication about whether or not they were going to show up or not? No. Hi, Miss Drake. Yep, we need to unmute you.
Hello there,
okay.
I'm here.
There you go. Excuse me. All of a sudden, a frog decided to get in my throat, I guess. So we haven't heard yet if our interveners are gonna participate.
I have not.
We don't know. Okay. Well, are we gonna have anything procedural that we need to deal with? Does anybody know of anything on the record?
Not for me, ma'am.
Okay, or before we go on the record, with regard to that. No one knows anything.
Ms. Hearing
I do
examiner,
have
may I
one.
just,
Ma'am?
can we switch roles? I can make you a host and you can make me co-host since
Okay.
you're taking over this. So,
Okay.
Now
Now I'm already a co-host.
Yes, but if you want, we can switch to host, and since I'm going
Okay.
to be on and off.
Oh, okay. Switch us up then, Miss Anna, while
Hold on.
we're waiting. Oh. And I guess before we get started, if we're still waiting for our pro se participants, the only,
So now I need you to make me co-host, please.
okay.
You-
Do.
There, perfect. Thanks.
Okay. Okay, no one has witnesses if, now that I've seen you. You may continue to have your audio or not until you testify. It's up to you. Although Mr. Chavez, I haven't seen your face. There you are. Okay, now I know it's you. I want to make sure it wasn't someone who was trying to impersonate you. Okay. Well, again, no one has heard anything from our 4 pro se persons. Well, I guess we have 6, but 2 did not participate in the stipulation, and the other 4 did, but no one's heard anything about whether or not they're going to participate in our hearing. Okay, the only procedural thing that I want to discuss has to do with one of your exhibits, Mr. Lewis.
Yes.
And what I would like to do in an effort to keep our record as clear and concise as possible, I believe it's your exhibit 3, which is your supplemental testimony. And you had 2 attachments. You had the certification of stipulation in the prior case 11-00001. And you also had the order. And what I would like to do, sir, is I would like to take administrative notice of those exhibits as being documents in the record and not include them in your attachment.
That's perfectly fine with me.
Okay, anybody have any, Mr. Badako or Ms. Drake, any objection to that?
No objections, Madam Hearing Examiner. That's acceptable.
Okay, we'll put that on the record. Also, I just as a matter of formality, I think I put in the email, or if I didn't, I'm assuming that since I didn't hear anything, nobody is going to object to the remote swearing of witnesses, um, or the fact that there's no notary public to verify the identity of the witnesses. Correct?
That's correct, Madam Hearing Examiner.
That's fine with
Okay.
me. I guess I would just have one question. Is the court reporter going to need the witnesses to show their driver's license or any other form of ID?
Melissa?
I believe the notice that I received said that I needed to see the IDs. So if they can just hold up their ID for me to see them, I believe that's fine.
That's
Okay.
fine. Mhm.
Okay, I haven't done it that way, but
have.
whatever Melissa says is good for me. Or I can tell you, I know the staff witnesses are who they say they are, and I'm assuming Mr. Lewis would not have put this upon himself if he weren't who he said he was, and I'm sure Ms. Drake can verify Mr. Key. Okay, all right. Well, if there's nothing else, then let's go on the record. Good morning. And I guess before we go, Anna, like I say, if you have other things, you can stay or go at your pleasure. Okay, very well. Good morning. My name is Elizabeth Hurst. I am the designated hearing examiner in our case today, case number 20-00-107. And this is in the matter of AV Water's request. AV Water Company advice notice number 2. And today is the date, time, and place for the hearing in this matter. As the notice that was sent to all of AV Water's customers pursuant to the procedure order that I issued, as well as the publication of the notice. Along with me today is our court reporter, Melissa Goodson. Should anyone need anything to do with the court, with our transcript, they will need to contact her directly. Also, our e-bailiff is our legal assistant, Anna Kippenbrook. We have someone that's a telephone person that is in the waiting room. Does anybody have any idea who that phone number is?
No.
On it, is there a way you can check that out? I can tell you for the record that no one.
No, without admitting the person in.
Okay. Hello, phone person. Who are you?
Hi, this is Karen.
Hi.
Lallup.
Pardon me? I think it's
sorry?
Ms. Northrop. Is that correct?
Yes, that's right. Yes, that's right.
Okay. And is your husband appearing with you or just you?
He's here. He's might man the kids, but yeah, he can say hi.
Hello.
Okay, I heard that. Good morning.
Morning.
And we're just beginning our hearing. My name's Elizabeth Hurst. I'm the designated hearing examiner. And we're conducting our hearing via Zoom here today. As I just
Sounds good.
indicated, there were no requests to give public comment orally in today's hearing. And I can note for the record that there were two comments that were provided to the commission. One which was opposed to the 27% increase. And the other comment, and that comment was from a Scott Creech, who indicated he had been a customer of AV Water since 2009 and lives in Aztec. The other public comment that was submitted was from a Miriam Browning, and it was a photo of something about Morningstar water supply system from 2019. There was no written information from Miss Browning as to whether or not she was opposed to the rate increase or not.
Mr. An
with
examiner,
this-
sorry to
Yes, ma'am.
interrupt. I don't know if our co-reporter catched the caller's name or names.
Thank you,
Can-
Anna. I barely heard that. I would appreciate those names again.
I believe, Ms. Goodson, that our pro se intervener, Karen Northrup, and her husband,
Fine.
Sky Northrup, are on the line.
Very good, thank you.
Okay, I apologize for that. Okay, so I think with those procedural matters taken care of, if we could just for our record go ahead and get the parties' appearances on the record. We have the Northrups appearances. Mr. Lewis, would you make your appearance, please?
Sure. My name is Randall Lewis. I'm the receiver for AV Water Company.
And Ms. Drake?
Joan Drake appearing for Stonetown Animas Lender, also just known as Stonetown. And appearing with me today is Mr. Maxwell Key, who is our witness.
Very well, thank you. And Mr. Bagatko, if you'd make your appearance, sir.
John Bagatko, appearing for the Utility Division staff, and I'm accompanied by three of my wonderful staff members. I'll let them introduce themselves. Thank you.
I'm sorry, I couldn't hear you, Mr. Bagatko.
You're breaking up.
John Bagatko, NMPRC staff, and I'm accompanied by three staff members. Is that clearer?
Yes.
All right, very good, thank you.
Is that good for you, Melissa?
Yes, ma'am. Thank you.
Okay, just let me know. That's why it's nice to have an e-bailiff like Anna, because she's watching you while I'm looking at documents, and I don't always see you. I know there's some kind of little function, I think, on Zoom that makes a little hand go up or something like that. But when you're trying to look at documents and flip your head back, it doesn't always work like that. Okay, I think we have all of our appearances. I guess I should just note for the record that there were other interveners, pro se interveners that did file in this case, in addition to the Northrups. And they are not appearing. As part of the stipulation, signatories, we had Tiffany Birmingham, who's a pro se intervener. And then we also had Kaylee Grothe, Grothe, who was a signatory on the stipulation. And then we've, in addition to them, we have the Haskells. And I will get you their first names. And that was Brianne Salazar Haskell. And John Bryce Haskell. Okay. Well, I guess we can go ahead and begin. If we don't have any procedural matters that we need to deal with right at this moment, let's go ahead and begin our evidentiary portion of our hearing. I would like to note that the hearing is being streamed on YouTube. And the only thing that you will need to make sure is if you're actually here in the Zoom hearing, that you don't have the YouTube open also. I've been advised by our IT department, that's what creates an echo because you're like watching the proceeding on two different devices. So I just go ahead and say that. And then I also say, hello in YouTube land. This is the commission's public hearing in case number 20-00107. This is in the matter of a rate increase request for AV Water Company. And we're here today and we're going to hear the stipulation that was filed by the parties. And what will happen for those not familiar with the proceeding is the testimony will be offered from the witness directly. The parties will have an opportunity to question the witness. When they get finished, I will ask any questions I have of the witness, and then we'll go around one more time, and the parties will have an opportunity to ask questions based on the questions that were asked the first time. So with that, Mr. Lewis, as the representative for AV Water, the receiver for AV Water, an attorney, and the commission has granted your request that you be able to represent yourself in this proceeding. So please go ahead, sir. And Melissa, if we could, if we could go ahead and swear Mr. Lewis.
Mr. Lewis, will you raise your right hand, please? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Would
And did you have your driver's license there?
There.
Yeah, I see it. It is pretty hard to read, Ms. Herring, examiner, but in all honesty, I've never looked at them before.
Okay.
I am familiar with most of staff's witnesses as well, and I don't think that it's necessary.
Okay. Oh, very well. All right, Mr. Lewis. You can go ahead and give us, just however you want to do this. If you just want to go ahead and offer your exhibits, or you want to give us a brief overview of what you do as the receiver, that's fine.
Okay. All right, I will try to, all right, I just had a dog run through. I will try and be brief and then let people ask questions. So I am the court-appointed receiver for the Morningstar water system, not all of AV Water, and not even at the time I was appointed, it had 2 water systems. I was only appointed for one, which is the Morningstar system. I was appointed by the court because for all practical purposes, the borrower had abandoned, the borrower, meaning the operator of the company, had abandoned the water system, and the lender, Stonetown, and as well as a number of other parties were anxious desperate to have somebody under court supervision to take control of this system and try and get it back to a safe and rightful place. By way of background, I am educated as a lawyer. I haven't practiced in more than 25 years, so I will appreciate any occasional guidance where I've wandered off. My expertise is in the process of managing complex receiverships, and so that's really what I bring to this discussion. This was probably this is one of the messier receivership cases I've taken on in some years. You know, you have a complex water system that was deeply in debt, on the verge of being cut off from its supplies, almost uninsurable, and the staff had not been paid. The staff was not covered by health insurance, and it was a scramble to get it stabilized. In the intervening time since my appointment in January 17, we have worked hard to instill stability, and at the beginning of 2020, we were at the point where we absolutely needed to address the revenue side of the company, the rate side, and we filed our rate case. We initially filed for the more streamlined 7.9% increase because that was the most cost-effective approach, and then we were invited by the commission to go to the long form process, which brings us here. We filed our case. We had the pro se interveners led by Karen and Sky Northrup, who had been involved with this really since the time we'd tried to start to address the revenue questions. Karen Northrup has been a very effective participant in this. I've not quite met a consumer advocate of her skill for being an engineer by training as opposed to a professional in this field. That has led us, with working with the staff, to the stipulation that we've presented, which is a remarkable effort of all of us. All the people here have participated fully in it, and each perspective has brought something to this final document. It achieves what we need, AV Water needs as a minimum, to continue its path out of receivership. It achieves, I believe, the goal of many of the interested customers to balance the rates in a way that makes it more, in their and my eyes, more fair, and keeps sort of the full weight of usage on each group appropriately. And most importantly, it establishes a repair and replacement fund that is a critical part of dealing with the aging system. The overall The overall stipulation is, as I say, a combined work product facilitated through mediator Glick, and we bring that to you today in hopes that we can get it approved.
Very well, sir. Would you like to go ahead and let's begin to admit your exhibit, sir?
Okay,
My understanding is that you have 5 exhibits.
I believe we have the stipulation, and then
Let's start out with your first exhibit, sir. I believe that's your direct testimony.
yes, I believe that is my direct testimony of
April 6th.
yes,
And that testimony, you filed an errata later, but the direct testimony as you offer it here today was true and correct to the best of your knowledge?
yes, ma'am.
And except for the corrections with the additional exhibits, corrected exhibits that you have in the errata testimony, is the information, if you were asked the questions today, would your answers be the same?
Yes, I believe so.
And any attachments that were included with that testimony, were they prepared at your direction and control, or
Yes.
under your direction and control?
Yes, ma'am.
Okay. And would you like to offer that testimony, Mr. Lewis, as Lewis Direct Exhibit 1?
I would.
Are there any objections to what has been identified by Mr. Lewis as his direct testimony from April 6, 2020, as verified by him here today?
No objections. Madam.
Hearing
No objection.
no objection. Mr. Lewis, Exhibit 1 is admitted. Mr. Lewis, it's my understanding that you also had filed errata testimony. And I believe that was filed
At May 7.
on May 6th.
Yes, May 6 or May 7. And we've marked that tentatively as Exhibit 2.
Okay. And that corrected some errors that were in your original testimony. Is that correct?
It corrected what we discovered right after we'd filed my original testimony, that we had a serious overbilling. And so we had to go back and redo our revenue numbers.
Okay. And that testimony was prepared by you or under your direction and control?
Yes, ma'am.
And the testimony is true and correct to the best of your knowledge?
Yes,
You don't have any additions, corrections, or deletions to that testimony?
I do not.
And if you were asked the same questions today, would your answers be the same?
Yes, ma'am.
Any objection to what's been identified by Mr. Lewis as his errata to his direct testimony to correct an overbilling situation? Hearing no objection. Lewis Exhibit 2 is admitted. Mr. Lewis, my understanding is that you also filed supplemental testimony in this case. Is that correct?
That is correct.
And that supplemental testimony, I believe you indicate in the testimony, was filed in order to answer some questions that staff and that the mediator wanted addressed. Is that correct?
That is correct.
And that testimony was prepared by you or under your direction and control?
Yes, ma'am.
And if you were asked the same questions today, would your answers be the same?
Yes.
And that testimony is true and correct to the best of your knowledge?
Yes, ma'am.
And you have some attachments to that supplemental testimony, Mr. Lewis?
Yes, we do. I believe those are the two order or the prior stipulation and order that we were discussing before we went on the record.
And that stipulation and order come from the prior cases combined. There was case number 11-00001, which was the certificate of convenience and necessity case filed with the commission, along with case number 13-00085, which was a complaint case relating to AV Water, and the certification of stipulation that actually I issued in that case was issued on or about the 9th of September. I'm sorry, 9th of December, 2015. And then the other document that you included as an attachment to your supplemental testimony was the order adopting the certification that was issued by the commission on February 24th of 2016. Is that correct?
That is correct.
And in an effort to streamline our docket, Mr. Lewis, would you have any objection if I take administrative notice of those two documents as being what they purport to be, and that they are contained in the commission's docketing system under those case numbers on those dates?
I have no objection to that.
And is there any objection from anyone else that I take administrative notice of those two documents? Hearing no objection, Mr. Lewis, I'm going to take administrative notice of the attachments to your testimony, and then would ask that your testimony, your supplemental testimony, be offered without the attachments. Any objection to that?
No, ma'am, that makes perfect sense.
And hearing no objection from anyone else, Mr. Lewis's supplemental testimony as prepared by him, true and correct without the attachments, Mr. Lewis?
Yes.
Very well. Hearing no objection, I will admit Mr. Lewis's supplemental testimony without exhibits into our record. Mr. Lewis, it's also my understanding that you filed a stipulation testimony in this case. That is your exhibit 4?
Yes.
And you prepared that testimony, sir?
Yes, it was prepared under my supervision and with my participation.
Very well. And is it true and correct to the best of your knowledge?
It is.
And if you were asked the same questions today, would your answers be the same?
They would.
Is there any objection to what's been identified as Mr. Lewis's stipulation testimony? Mr. Lewis exhibit 4. Hearing no objection, Lewis exhibit 4 is admitted. Additionally, Mr. Lewis, it's my understanding that for purposes of the record, you also are offering, I believe, what's being referred to as signatories exhibit, or a signatories exhibit, and that's Lewis exhibit 5?
Yeah, I think we marked it as signatories exhibit 1, but whatever makes
Okay,
record sense for you.
okay. Signatories exhibit 1, and it is the stipulation, correct?
Yes.
and it contains attachments.
It does.
Regarding revenue and other matters, correct?
Correct.
And are there any objections? To the best of your understanding, Mr. Lewis, it's a full and complete copy of the stipulation and attachments that were filed with the commission, correct?
Yes.
Okay. Any objection to signatories Exhibit 1, the stipulation of the parties and accompanying attachments? No. Okay. I will admit signatories Exhibit 1. Did you have any other exhibits, Mr. Lewis?
No, none that I feel that are needed now. We may have, I have extra, several other things just in case we need to refer back to them. For example, the staff had asked several questions of me, and I don't think we'll go to those places, but I have them handy and marked if we need them.
Okay, very well. All right, well, I guess we will go ahead, and normally what happens at this point is we go through our questioning, and it's going to be based on the intervention date. So Karen and Sky Northrop, do you have any questions of Mr. Lewis?
No, we don't have any questions at this time.
No,
Okay,
no questions.
thank you. The next party then, Ms. Drake, do you have any questions for Mr. Lewis?
No questions at this time, ma'am.
Very well. Mr. Bagato, any questions from staff?
Staff has no questions for Mr. Lewis. Thank you, Madam Hearing Examiner. I hope you can hear me now much better.
Okay. You know, and just for those not familiar with commission procedure, or especially when we have a stipulation, it is pretty much normal for parties that have reached an agreement to not have questions of each other's witnesses. So this is not unusual. And for those who know me, it's not unusual for me to have lots of questions. So I will, I'll go ahead and begin. And I guess first, Mr. Lewis, I guess I would just like to know a little bit, since you're the first receiver that I have dealt with in a case, and would just like to know, number one, I mean, I have read your testimony, and would like to know whether or not in your capacity as a receiver, if you have ever dealt with a public utility before.
I have not. I have dealt with related entities in other states, special districts or metropolitan districts that provide water services, but have not previously dealt with a regulated utility in this environment. I've also done cases for the federal government with other kinds of regulated entities, but again, not a public utility.
Okay, and have you had experience in the in your work as a receiver to have had to deal with rate making concepts or how public rates for an entity are set out?
In at least three limited senses. Again, in the non-utility providers that are particularly prevalent in Colorado and Nebraska, rate making is for a metropolitan district or a special district is less structured. It's still a public process, but it doesn't have the same rate making and the regulatory structure that the PRC system has. So the answer on that is no, not in this sense. I have appeared in my capacity as a receiver in rate making proceedings in Colorado and I want to say Wyoming, but they were in other industries, trucking industry cases, as an, if I recall correctly.
Okay. You haven't appeared before our commission in transportation cases though, have you?
No.
Are you aware that the commission regulates certain transportation activities?
I am.
Also, sir, within the concept of being a receiver and your powers and duties, what is the primary objective of the receiver?
Every case is different, and so the objectives of each case are usually set out in the order appointing the receiver. The order is, I think of it as sort of my operating agreement between myself in my capacity as receiver and the judge overseeing the case and the parties involved. But in this instance, the direction was to take control, stabilize, and work the company back to a place where it could be sold for the benefit of the creditors in the receivership case, the company, the outsiders who have interests in it. In my language, the company is solvent, so the equity owners are no longer relevant. They are out of the money. And so the real beneficial owners of the company at this point are creditors. And so the purpose of the receivership is to care for and provide service to the customers and to build value in the assets so that they can be sold, so that then the court can determine how that money is split up among the now beneficial owners, the creditors.
So based upon those objectives, I mean, are there any potential conflicts for you? I mean, for example, part of the charge and duty of the Public Regulation Commission, is, to regulate the utility. However, for example, in a lot of what the commission does, it's not just have they, complied with this rule or that rule, but there's a balancing that goes on between the utilities' right to do business and in the public interest consideration of the ratepayer. And I just wondered if the real if the real owners are the creditors and one of your goals is to build value to sell the company, presumably so that the real owners, i.e. the creditors, are going to get paid, but then also to provide service to the current customers, whether or not there's any potential conflict there.
I would say in all of my cases, because I tend to take only the messiest of cases, conflict among the parties is potential conflicting interests among parties is an embedded part of the case. It's why courts appoint someone like me and not a more sort of run-of-the-mill receiver. And so let me just, if I may, go a step beyond that. So the history of receivers is that they are a manifestation of judicial authority. So the court can't actually take possession and operate a water company or a railroad or, you know, an investment company or whatever. And so in the history of first English and then American law, receivers were evolved as the, it sounds a little silly, but sort of the personal embodiment of court authority. So since the court couldn't do it, they created this person, a receiver, and transferred the assets to that person to receive them and hold them for the benefit of the court. So it's weird and it gets a little confusing at times, even for me and for the judges that appoint me. But you know, my job is to execute that court order within the best of my abilities and to use my good judgment to, you know, balance all of these interests. But in the end, the court is the one who approves and disapproves of my behavior. My duties in all receivership cases run to the court. And so when dealing with regulated entities, whether they're FDA supervised companies or securities companies or a utility, you know, we have a classic issue between branches of government, the executive branch and the judicial branch. And so, you know, it's easy to get myself tied up in knots here, but if I stay focused on what the court wants me to do, and you know, in different jurisdictions, it's different. When we're in the East, the judges talk to their receivers informally all the time. In the West, that's a little unusual. It happens from time to time. In Colorado, it never happens because there's a rule that says, you know, if the court and the receiver are talking, they do it in open court in a hearing, not in the judge's chambers, you know, over coffee. And other parts of the world, it's less formal. New Mexico's pretty close to Colorado in that approach. They prefer to keep everything in the open. So we try to communicate with the court by status conference and advise them of what we're up to, so that the judge who's responsible for me has a good idea of whatever it is I'm up to.
Okay. I know you've indicated in your testimony, sir, and here today that one of your missions that is to build value in the company. So ultimately, it can be sold. That's correct?
Yes, that's what the court has ordered me to do.
And at this point, my understanding, based on filings, in court filings with the 11th judicial district in two cases that are currently going on, that you actually have a motion to approve asset and real property purchase and sale agreement that's been filed. Is that correct?
Yes, ma'am.
And it is, the purchaser would be a company named New Mexico Water Service Company.
Yes.
And there's an offer out there to purchase assets and real property that are contained in an agreement that's been deemed confidential. For a purchase price of $4.5 million. Is that correct?
Yes.
And that's pending.
Yes, ma'am.
And can you, without violating anything under the asset and purchase sale agreement, can you tell me whether or not this agreement entails the assets that you are shepherding right now?
Yes, it does. That's why it's submitted to the court for approval. It comprises all or substantially all of the assets of the Morningstar water system that are in my custody.
Okay. So when last I saw AV Water, approximately 5 years ago, I think as you have indicated, AV Water was comprised of two systems, correct?
Yes.
It was comprised of the Morningstar system, and it was also comprised of the Harvest Gold system, correct?
That's correct, yes.
Do you know what happened to the Harvest Gold system?
The Harvest Gold system was not placed in my custody, so I don't know a great deal about it. It was eventually, I believe, formed into perhaps something of a mutual company that the property owners, customers in that area took over that system. But that was a pretty complicated asset that was outside of the scope of the receivership.
Do you know what happened to the AV Water assets that were contained within the Harvest Gold system?
Like I say, they did not come into the receivership. I believe the company and the lenders abandoned them back to the customers. But again, we're way outside of what I know.
Okay, and I don't know as a financer, if you don't know, sir. I say I'm just trying to put my mind, focus my mind on what I know about the system and when last I saw it. And things are different now, and I'm just trying to figure out if anybody knows why, when.
Madam Hearing
How?
Examiner? This
Yes,
is
Ms.
Karen
Luther.
Northup. I was involved in that, the one in Bloomfield, apple
Okay.
orchard apple or something.
Okay, well-
I worked for the firm at the time that did the system of the flushing of the system and trying to get it back up. The Harvest Gold was too dilapidated. The fresh water coming in was like a cesspool of water. It wasn't cleanable, basically. They couldn't get it to a point that was potable. So they had to connect into the Bloomfield system. And in order to do that, they had to be their own domestic water system. So basically, AV had to abandon all those assets just so because those people were bottling water and hauling water for months. And they essentially were forced to forego those assets in order to get those people to be hooked into Bloomfield water system.
Okay, thank you. So as you've indicated, Mr. Lewis, in your testimony, ultimately, there was an initial application, and then there was a second application filed in this case, and that second application requested pretty much a 27% revenue increase. Is that correct?
Yes, the sequencing is a little bit different. We filed the first request, and as we went into mediation and the interveners appeared, the commission directed us to go from the more streamlined process to the full long form. I've forgotten the name, its formal name process. At which point we amended to include, we decided if we were going to go down that path, we might as well ask for the revenue that we actually needed and not just, a bite of it.
And my understanding, as the justification for the increase, your testimony says that the 27% would cover expenses, make some contribution to debt service, and would have a 0% return on equity, which we call an ROE. Is that correct?
That is correct. Then to be clear on the debt service, the 27% permits us to pay current debt service, not anything that is past due.
Okay, so would that be the full amount of the debt service payments?
It would be the full amount of the interest payments owed on the money borrowed by the company.
Okay, just the interest. It wouldn't actually allow you to make the agreed upon payment.
No, it would only cover the current interest payments owed under the contracts.
And then once you filed your errata because of the overpayment of two of the commercial customers, actually the 27% won't cover revenue or the debt service interest, will it?
It gets very close. I mean, there was a little bit of slack, but with the overbilling error of, that it will be much tighter than it would have been under the original model.
Okay, I thought I read someplace that you actually would have to have like 30-some% now to actually break even. Is that not correct?
That is correct. My point is I believe that we can find ways to operate efficiently and continue to save money to pay debt service currently. Without jumping ahead, the key here is the structure of the R&R charge and then the restructuring of the rates. I believe that gives us the flexibility to meet the current debt service.
Okay. And I guess before I go too far, I know in the errata testimony that you testified that part of the overbilling mistake was due to the calculation of how the water that was being used was being quantified. Is that correct?
Yes, you're being quite kind. The issue was we had an operator who replaced a meter, a commercial meter that measured in gallons with one that measured in cubic feet, and the billing company was not informed of the change, so we were calculating their bill on the wrong information and substantially overbilled the company until we caught it.
And how are you remedying that error?
At this point, the immediate thing was to immediately replace the meter with a meter by gallons. We have an agreement with both creditors that we read the meters together so that we're both confident that the numbers are correct. And as far as the overbilling goes, particularly with the larger of the two, they are at the moment allowing us to credit their current bill against the overbilled amount for it will be a long period of time.
Okay. So basically they're not going to pay a bill for a while.
Yes, ma'am.
Okay. Cause that overbilling was a couple $100,000.
It was $100,000.
100,000. Okay. And just so that I understand, how are your bills read?
How now? I mean, we do them by human beings checking them every. We have 7 or 8 routes, and when I arrived, all of them were read. All 8 routes or 7 routes were read all at the same time at the end of every month, which led to a lot of mistakes. Now they read 2 every week, so that they can usually be done in a day or so, and the reading schedule isn't disrupted by water breaks or whatever, and that's part of how we've solved some of our billing problems.
Okay. And are these company employees or is this contracted out?
Company employees.
And so you send out staggered bills or everybody gets a bill out the same day?
No, we send bills weekly. So we do a staggered billing, which isn't optimal in many respects, but given the tightness of resources, it was our most efficient way of stabilizing the situation.
How would you characterize the timeliness of your bills now?
Substantially better. I don't think we've missed a cycle in more than 18 months.
And when you say missed a cycle, you mean a whole month's worth of billing was missed previously?
No, that we'd slop into 45 days. When I got there in January of 17, bills had not been sent out for 8 months prior to my getting there. And it took us the better part of 60 days to get enough order imposed to be able to get bills out. And we went then for 90 days because it was, we had to go back and get baseline reads on every meter again to figure out where we were. There was no point in harming the customers by then slamming them with giant bills. So then we went to base only bills for about 90 days while we continued to sort ourselves out and then restaff. And then we gave everybody notice that we were going to move to then back to consumption-based bills. And then we went to this 2 routes a week model. Again, because we can only afford to have somewhere between 2 and 3 people in the field at any given point in time. And so, even though it's a big system, we've got it down to a science now where they can read the bills usually in a day, or read the meters in a day. Then the office staff can get them submitted and the bills go out.
Okay,
It's not the perfect or typical way of doing it, but it's working for us.
okay, very well. And am I correct? Did I read in your testimony that currently you have approximately 1,875 meters?
About that, yes.
And do you know if that's an increase or a decrease from what I would have seen 5 years ago?
I think it's pretty close. It's probably a small increase. There have been the addition of a few commercial accounts, and then as houses are built and brought online, there's probably been some steady growth, but not explosive growth.
And when I've seen numbers, I've seen numbers quantified by referring to them as taps. I've seen numbers quantified by referring to them as meters. Do you know if those are the same things?
In our system, they're not precisely the same, but we refer to customers by meters and not necessarily by taps, because as you saw in the testimony, we have these sort of +1 rental situations where there's a house plus one additional mobile home or something on the property. And that's usually on one tap with either a single meter or 2 meters.
Okay, so then if you say 1,875 meters, then you're also referring to 1,875 customers?
Yes, ish. I don't mean
Okay.
imprecise, but it's not perfect.
Okay. Again, just trying to make sure I understand that I'm comparing. So for example, just to let you know, if you looked at the certification to stipulation in the 11-00001 case, the Harvest Gold system was described as having approximately 140 taps, but it served 500 customers.
Oh,
So,
okay. Yeah, I wasn't aware of that.
so like you say, just trying to, again, get my mind so that I understand what's going on.
Yeah.
Okay.
You may,
Another thing I wanted to ask you is, in reading the part of the order. And I guess actually I was looking at the motion. I was looking at the motion to approve the asset and real property purchase and sale agreement that was filed. I don't have a filing date on this document, but was filed in the 11th district. And the question I wanted to ask you is, I believe I read in your testimony that you indicated that you do not have the authority to sell any of the individual assets. Is that correct?
that authority is vested in the court, not in me.
Okay, because the claims being made in this motion at item 4 of this motion, the receiver's authority in these orders is consistent with the New Mexico Receiver Act, section 44-8-1, specifically 44-8-7H, grants receivers the authority to inter alia sell or mortgage the property of the receivership estate.
Yeah,
So
That is what the statute says, but the actual order that appoints me does not give me the capacity to sell the system without further action of the court. It
Okay,
requires the court to act. And this is why I make this distinction that my authority is 100% derived of the order that appoints me. And, you know, judges have the right to make them narrower if they choose to.
uh-huh,
And in this case, the original judge in the case, you know, and the creditors involved in the case all wanted to be sure that they had some say in this, and I didn't just go off and sell it for $1.
okay. Very, very well. And I guess what I'd like to do is in looking at your Lewis Exhibit 1, your direct testimony,
Mhm.
you have indicated in your filing that the assets of the company are very limited. Is that correct?
Yes, I mean, the assets that are within my control are particularly limited, but the AV Water, between foreclosures by creditors of non-regulated assets, land that it owned, is really down to a relatively small number of assets. The water
And
system.
and that's goes to the heart of my question, trying to figure out, Mr. Lewis. In basically what in the application in your testimonies you've indicated that there's the plant and services is only 4 things. You've indicated there's a pumping station that was built in 2016, 4.7 million gallons of storage that is from 5 tanks, 50 miles of distribution line and water rights. Is that correct?
That is correct.
However, when I go back and I look at the amended application in the CCN case, which was the 11-00001, or even if I look at the stipulation exhibit 5 to that stipulation, which has plan and service numbers and different rate numbers. It seems to me that there were a significant amount of assets. The lines total 64 different assets that were listed, and this didn't even include the water rights. Are you familiar with those?
I am, familiar with the assets that came into my control, which are the 4 that you enumerated. I'm aware that assets like the water treatment facility had either reverted to the lessor from whom they had been leased, and I'm will confess my ignorance that I am not aware of what else is in the 64, the other 60 lines of that schedule. I can I think I can pull it up and look at it with you if you'd like.
Well, just generally, I mean, there are things like collection basins and pumps and booster pumps and all kinds of filters. There's pressure relief valves, hydrants, etc. And I'm just wondering what happened to all of those things that I mean, there has been no abandonment proceeding that I'm aware of where AV Water came in and asked to abandon those assets.
So that may be my fault in not. So all of those things, the hydrants, the pressure relief valves, the pumps that are attached to the storage system, to me fell within the nature of the assets that I have in my control. The water treatment system, the filtration system, that never came into my control because the company had stopped using it when it did its emergency cut over to Farmington. And so that was never within the scope of the receivership. And so, you know, I may have assumed that the lines with all of those things attached would be a number of those items that you touched on.
So just so that our record's clear, that's another big difference from 5 years ago, is that rather than actually diverting and treating the water from the Animas and San Juan rivers, AV Water now purchases bulk treated water from the city of Farmington. Is that correct?
That is correct.
And do you know, I was looking at that agreement. Do you know what the current rate per gallon is?
I believe it is, I knew you were going to ask me this. I want to say the rate per gallon or rate per thousand is something in the ballpark of $2.29 per thousand. $2.29 per thousand. I think that's right.
Okay.
My notes quickly.
I know that there was a contract extension, and also I think in looking with that agreement, there was a potential for change. And I just wondered if from the last enumerated contract term it had changed.
No, I don't believe so. We're coming up on the end of the sort of the 5-year period of the current contract. And so, you know, absent a sale, that's going to be something I'm going to have to turn to.
Okay. But right now you think it's 229.
Yeah, I'm pretty sure it is.
Okay. So then potentially some of the assets that AV Water claimed that they had before, you might still have those assets, correct?
Right. I you know, it's, as I say, it's my lack of complete understanding here. So to me, the water system includes attached items like pressure release valves and hydrants. And you know, it's my error to not have included the booster pumping stations as separate assets.
And you believe that that you don't no longer have the treatment building?
That is correct.
Okay, because there was a lease for ground underneath that treatment building that was in place 5 years ago. But it wasn't the building itself, it just was a ground lease. Are you familiar with that?
I am not. As I
Okay.
said, when I arrived, all of that had been, the operations of that had been abandoned. And you know, water was coming from the city of Farmington into the primary pump station. And that was where I started.
Okay. And I guess just finally on the customer total, well, that combined both systems, that's not gonna help, never mind on that. Do you know also one of the prior issues, they had a really big system loss, approximately 35%. I mean, that was disputed in that case, but do you have any information on the potential system loss utilizing the city of Farmington water?
I'm sorry, I'm struggling with the definition of system loss. Can you, I don't want to answer the wrong question here.
Okay, well, my understanding of system loss is that you're pumping more water than you're actually collecting. So
Oh,
you're losing a bunch of water somewhere.
we have had substantial issues with that. We have it down to, I believe, we're down in the single digits now from where we were. When the system switched from the pump station to from the treatment facility on the Animas River to the city of Farmington, the system went through an extended period of major breaks, which ultimately, real engineers could tell me better, but I'm told that just by reversing the flow of whole sections of the water system, that puts different strains on things. And so it takes the system quite a while to settle down. So we had a lot of large breaks. The other thing we had was a severe lack of valves in many of the main lines. So when they would break, it would take the entire 3 or 4 million gallons off the hill to drain out of the system. And then the repair could be completed, and then the system would have to be refilled. We have not had one of those in a substantial period of time, and every break we put in more valves.
And in that particular pumping station, my understanding, the 2016 pumping station was built to facilitate a water transport uphill from the city of Farmington to AV water system. Is that correct?
That is correct.
And that is an AV water asset, correct?
That is. Yes.
And, you know, I guess we can go ahead and since we're on this topic, go ahead and talk about this. The water rights that are an asset that you're in control over are approximately 787 acre feet per annum of consumptive use. Is that correct?
I believe that's correct.
And again, that's for both the, it's comprised of water diversion rights from both the Animas and the San Juan, correct?
Yes.
Okay, so nobody's gotten rid of any of the water rights.
No, the water rights we are holding on to. There, as I noted in my testimony, they are conditionally assigned to the city of Farmington to, as part of the the bulk water purchase agreement.
But they're not all conditionally assigned to the city of Farmington, are they, Mr. Lewis?
I don't believe that they're all, but a substantial portion of the critical ones are. Again, we're getting deep into territory that I don't have complete knowledge of.
Okay, well, I seem to have made a note that you're only actually, based on the number of gallons that you're pumping, that you're only using approximately 462 acre feet of those water rights, which would give you an excess of 325 acre feet of water rights, wouldn't it?
Yes, I'm guessing your math is quite correct.
And then if you look at your attachment 4, page 4 of 6, which is the AV water purchase contract, at item 12 entitled water rights, 5 lines down, it says the city may require AV water to provide the necessary water rights to cover the amount of the treated water supplied to AV water. And then it goes on and on and on. So I guess, Mr. Lewis, I read that is that they could ask you to, to provide those, but only up to the amount that you're actually pumping. Is that not correct?
I think I'm scanning down to that paragraph right this second.
Okay.
But I believe I believe the way I understand our relationship with the city is that they claim a right for us to make them all available to them based on our usage. So I don't think they have claimed, we haven't actually done anything other than to not further encumber them to ensure that the city is covered, but those water rights, all of them, to the extent we are using it, are available to them, to the city. I hope that makes sense.
No, it makes sense. It just looks like to me that if the contract only requires you to encumber them up to the amount that you actually use, that that excess or surplus might have potentially been another income source for the utility, but I have no idea. I'm just asking you what your perspective of the contract is.
Well, the way I look at the water rights is probably a little more, I look at the city's agreement and say we have to cover them, but I look at the water rights themselves, which appear to be quite good rights as they are currently used as owned by the system, as a part of the value that a potential purchaser would pay for. We haven't investigated, partly because of the engineering and other costs involved in separating that out and trying to either monetize or convert some of that into income. that's probably more than I could get to with the limited resources I had.
Madam Hearing Examiner,
Yes, Ms.
this is
Northrop.
Karen Northrop. Is my understanding the way the water rates work is that you're allotted a
You're
certain
just-
amount per
Wait
acre,
just a
right?
second, Ms. Northrop. You're not sworn in as a witness. So I
Oh.
really can't have you testify right now, but if you want to just make a note to come back and tell me later, then I'm glad to hear from you.
Okay, sounds
but
good.
I can't have you testify right now, okay?
Okay, thanks.
Okay, thank you. You know, and that's fine, Mr. Lewis. Again, I'm just trying to get some clarity here on exactly how the system's being operated, what's being paid for. And again, based on your plant and service items, I mean, it sort of looks like to me that really the bulk of the value of the plant and service is the water rights. Isn't that true?
That could be, yeah. I mean, they are valuable water rights.
As part of your duties as being a receiver, did you go back and do any cost comparison, for example, on how much when you're developing your rates or your rate design, did you go look at the cost of the prior cost of treated water versus the cost of purchased water?
No, I'm aware that the purchased water is more expensive than the company previously paid, or that it cost it to produce its own water. But I'm also aware that that was the source of a great deal of the difficulty between the company and the system and its customers. That treatment plant was the source of the contamination for pushing all the Storm King Gold King polluted water into the system. It was also the source of, constant issues around sedimentation and other quality issues. Since again, that all predates me, but with the transfer to the city's treated water, all of those customer issues in that vein have gone away. We've not had any of those sorts of issues since I became receiver.
And it is higher than it was when they used to treat it themselves. Would it surprise you? It was approximately $100,000 to treat the water themselves compared to, I believe, the $333,742 cost of water from the city of Farmington.
Those numbers sound close to correct.
And also in your testimony, it's my understanding that the past due balance to the city of Farmington has been paid off now under your direction and control, correct, sir?
Yes, ma'am. When we got there, they were literally, the city was to the point of wanting to cease providing service. They were owed. Right before I became receiver, Stonetown actually made a payment of $50,000, and then we worked off the balance of the $150,000 over the past 3 years. We paid it off earlier in 2020.
So then could you characterize the relationship between AV Water and the city of Farmington regarding the purchasing of water to be a more stable relationship?
It has been since I got there. It was probably not very stable when I walked through the door, but the city, through the Director of Public Works and the city manager, have been phenomenal partners to me in moving this process forward.
Do you know whether or not in Schedule F1 to the application, you stated that AV Water doesn't have any other property or investment? To the best of your knowledge, AV Water does not at this time own any real property?
Other than the real property under the system assets, that where the tanks are and the pump house, it doesn't own anything other than the line easements and that property that I just described.
So any of the land under the treatment plant or anything, all of the equipment and buildings, structure that were down near the rivers, are AV Water no longer owns?
It was my understanding that all that was forfeited back prior to me becoming receiver under the default in the ground lease. In the
Okay.
lease, I didn't realize it was a ground lease, but it was my understanding that all of that was forfeited back.
Do you know whether or not anybody's doing anything with it?
I believe there's some sort of operation going on down there, but it's not producing domestic water. The owner, which is Andrea Corp, also the mortgagor of the water rights, has got something going on down there.
Okay. Well, let's talk about Andrea Corp. That's who owns the water rights, correct?
No, AV owns the water right.
Or
Andrea
I'm
Corp.
sorry. That's who has the mortgage on the water rights.
Yes,
And that was a $2,450,000 loan at 5%.
yes, it was a carryback arrangement that was part of the in the history of this, as I understand it. That was one of the completing that water purchase arrangement with Andrea Corp was one of the things that had to be done as part of the prior case. And so AV Water purchased the water, has the title to the water, subject to the carryback financing note and mortgage to Andrea Corp.
And under the terms of that, AV was supposed to pay $150,000 a year, plus 5% interest.
I think it was I was thinking the 5% interest was the 150, but I'll have to check my notes. But suffice it to say, almost no payments have been made under that loan.
Okay. And then also there's a loan that AV Water took that was supposed to be a short-term loan with Stonetown Animas Lender at $1,857,692 at 11%. Is that correct?
At the time of the prior case, yes, that was correct.
And almost nothing's been paid on that either. Is that correct?
That's correct. That's the reason that Stonetown with others sought my appointment as a receiver.
And it's my understanding that Stonetown, that was supposed to be, that was supposed to be a short-term loan and it was supposed to have been renegotiated to be a lower interest rate loan by the prior owners. Is that correct?
Yes, I believe that's what, the company had been told to do. It never managed to do that.
Okay. And I believe you also testified that that money was supposed to be applied to the company. Is that correct?
I don't know that I know the specific uses of it, but it wasn't supposed to be wandering off into other places. As near as I can tell with my very limited knowledge, I can't tell what the company did with the money it borrowed from Stonetown.
You don't think they applied it to the maintenance and running of the system?
If they did, it was happenstantial.
Okay. And then I believe you've also indicated that Stonetown has provided another loan to AV Water after this particular point in time. Is that correct?
What I testified to is that to fund the initial operations of the receivership, AV Water, the Stonetown advanced to me in my capacity as receiver of AV Water an additional $260,000.
And I just wanted clarification because I wasn't familiar with the term, something for receiver certificates.
Yeah, so that's a receiver certificate is the language in my world for how receivers borrow money. We don't sign promissory notes. The order says that we can borrow money and evidence that borrowing through a certificate signed by the receiver that is then a first and prior lien on the assets of the estate, whatever that might be. So Stonetown provided additional money that, some of which we use for the city of Farmington, some of we needed for insurance. Literally there was $1.5 million or almost $2 million accounts payable balance when I walked through the door. And, and employees needed to be paid. So Stonetown lent me the money to start resolving those problems.
And what, if you can recall, what were the other creditors included in the amounts payable?
Oh man, it was everything from the New Mexico Department of Revenue was owed a substantial amount of money. Most of the suppliers in the Farmington region had cut off the company for failure to pay its bills. There was insurance, there were construction on that 2016 pump house, there was engineering firms. I think Miss Northrop's firm actually was one of them. So I'm just envisioning the list. There were suppliers and critical contractors and parts vendors, and then there was taxing authorities, others, back payments to Andrea Corp in the third column. Sorry, I do this by a 3-column system, and so I sort of envision the people in the right-hand column have legal claims to assets of the estate, so they tend to go last. The critical vendors and employees tend to go first.
Okay, and then who's in the other column?
The middle column are people like the taxing authorities, state, federal, gross receipt taxes, things like rent for the office, that sort of thing. sort of more immediate, but not critical.
So, and so what kind of headway did you make on that? Did you say 1.5 million?
$1.5 million, yeah. So the worst of it is in that right-hand column. That would be the people with contractors or mechanics liens or Andrea Corp. We were able to clear over a period of months the people in the urgent column. We went to every vendor and said, City of Farmington was in that group, and so the city agreed to a payment plan. Others agreed to payment plans. And we were able to retire most of that, other than the City of Farmington, within 5 or 6 months.
Okay.
The super urgent employees and their health insurance and property casualty insurance, liability insurance was all paid out of that pile relatively quickly. In the middle column, we're still working our way down through those. There's an administrative rent claim that will be paid at the time of distribution of the proceeds. You have to I don't want to get off on a tangent here, but in receiverships, the cost of the receiver and all of those things come off the amount available to creditors, at the time the case is closed. So the receiver certificate will be paid back. The unpaid rent would be paid back to the creditor, to the landlord, whatever else is in that pile, which isn't very much, or very many claimants, my fees, all that stuff gets paid. And then what's left is divided up by the court among the various claimants to those funds.
If the sale goes through, is there any chance that the prior owners are going to get any of the money?
None. Most of the creditors are going to take a pretty substantial loss.
Okay, because I know that, for example, on page 6 of your direct testimony, when you're describing your receivership role, you reference the, page 4, where you're talking about the background. You bring up another case involving AV Water, 16-00175, where you refer to AV Water and former manager, Mr. Upenlatz. There was $1 million fine put forth. That didn't get paid either, did it?
As far as I know, it didn't. Again, that predates me and
Okay.
the scope of the receivership.
And at the time that I heard the certification 5 years ago, it was Mr. Upenlatz, and then the testifying partner was a Mr. Eckert. And I wondered if you knew whether or not they still had any ownership interest in AV Water.
Well, technically they are, I've never heard Mr. Eckert's name before, so that's a new one for me. But technically the shareholders of AV Water or Animas Valley Land and Water still have their equity interest, but they are so far underwater, if you will, behind all the creditors' claims, that they have a legal interest, but they have no practical interest.
Okay.
That's who, for example, that's who the tax return for the assets that are in my control, the federal and state income tax return would be reported on their tax ID number.
Okay. Okay, well, at this point, let's go off the record just a second. Melissa, how are you doing? Shall we take a 10-minute break?
That would be nice.
Okay, let's take a 10-minute recess and we'll come back at 11 and I've got some more questions for you, Mr. Lewis. So,
Okay. thank-
people, if you are new to Zoom or not new to Zoom, if you leave your mic open and or your video open, people are gonna be able to see whatever you're doing. If you're back there dancing or whatever, something happy, I don't know, just to let you know. So thank you, and we'll resume in 10 minutes. Okay. We're almost back. I think we don't have Ms. Drake. Okay. Okay, Melissa, are we ready?
I'm ready.
Okay, oh, there's Ms. Drake. Okay, Mr. Lewis, to go back to, prior to the break, you were talking about the $1 million in accounts payable that were not being paid, correct?
$1.5 million, I think we were at.
Okay, $1.5 million in the accounts payable. And I know on page 7 of your direct testimony, you're explaining the actions that you've taken as receiver to manage the company. And on page 7 at item 16, you say brought the company up to date on taxes owed. Does that mean that the taxes that are owed are paid?
Yes, ma'am.
Okay, and does that include any arrearage amount?
It does. We had, the best way to put this is we had a mild jurisdictional dispute early in the case between the New Mexico Department of Revenue and the receivership court, but we were able to work that out and pay them off.
Okay. And then further on page 8, you're continuing that list, and on item 4, you say installed new isolation valve. And on item 5, you have rebuilt PRVs. And I know a PRV is a pressure relief valve.
Mhm.
Is that the same thing as an isolation valve?
No, in my thinking, isolation valves are the valves I was referring to where they go in line to prevent water loss. So when you have a break below a isolation valve, you can stop the water and you're not draining the entire system. So there were very few of those in the AV systems, which led to those massive water losses we were talking about earlier. So we have now a policy of putting a valve in on either side of every break to allow us to finish it, but also just to create more isolation valves so that when a piece of the system fails, we can isolate the failure to a very small area, relatively speaking.
Okay. And then at item 12, you have replaced aged infrastructure within budget.
Yeah, that's a.
Can you elaborate on that?
Yes, I mean, it's everything from in one place, we found industrial grade, not human grade, rubber hosing connecting a pump to a distribution line. So we took that out and replaced it with proper tubing, or flexible connection. It can be stuff like electrical panels that were falling off walls or poles and needed to be rebuilt and put back on. It's one of those I could go on, I'm afraid, far too long about the quality of what we had there. As we noted, in some places when lines broke, we discovered that there was irrigation grade, not domestic grade PVC in the line.
Mm-hmm.
We found places where the quality of the the pipe hadn't been properly bedded, the ground heaved, and it would, instead of breaking in one place, it would shatter for 100 feet or more. And so it's a legacy of a old baling wired system that we're every chance we get, we try and make it a little bit better.
And can you approximate what kind of expense that you have put out since you have been managing the system?
Well, I think our sort of repairs and related costs last year were about $300,000. And that's been the biggest driver of where money goes, and the priority, that's the top, other than paying wages and insurance. And in the 2017, 2018 timeframe, I actually think the number might have been a little bit higher because it was nonstop. It was I learned, let's just say I learned a great deal about waterline breaks in that first 18 months.
Were you starting to regret your decision to accept the receivership?
With this one has been a challenge. I mean, I've come to love the people. I don't often love this system, I have to say.
And I guess, sir, I'd just like to take a look at some of the expenses so that I can get an idea of what's going on with the system. So I know if you look at your corrected Schedule A1, it is the summary of your overall cost of service and your claimed revenue deficiency.
Okay. It's going to take me a sec to get there. So the corrected A1, you're referring to the one attached to the errata?
Your errata.
Yeah, okay, I'm there.
And under there you have expenses, correct?
We do.
And according to this, your highest expense is actually to the city of Farmington, correct?
Yes.
And then your second highest expense would be your payroll.
Yes.
How many employees does the company have?
It's ranged from 2 to 7. As I'm sure you know, the sort of minimum wage nature of some of this, leads to some transitoriness. And in these numbers, I mean, we had some higher paid people and some lower paid people.
Uh-huh.
So.
Well, for example, on page 15 of your direct testimony, you say that there's a receptionist, a billing clerk,
Yep.
an office manager, and 4 licensed operators. Now, are they all full-time employees?
They are, but right after this, we downsized again to, I think we have 2 licensed operators and 1 helper, the receptionist who's now being jointly a billing clerk and our office manager. So we laid off about half our people.
Okay, so you have 3.5? No, 4, 5, 6. You had 7 and now you have 3.5?
Office manager, receptionist, and 3 people in the field.
Okay.
So, and we've also been optimizing our salary structure to save some money there as well.
And then you, do the operators read the bills or read the meters?
Yes, those three people are do it all.
Okay, I guess I was kind of thinking that they would be the ones that would be installing new, new meters or whatever, but no.
They do everything.
Are you still contracting out work?
The only work we're contracting out now is I have a monthly agreement with a company who provides me a level 3 and level 4 water system operator to provide some supervision to the less experienced people. That's a fixed cost per month.
Okay,
And then our billing systems are run through an outside vendor. And then other than additional contractors.
okay, so your billing is actually done by an outside,
Company, yes.
you don't think that's something that can, capable of being done in-house?
Not so far. I think with the thin staff we have, to me, it's one of the savings that can be immediately realized for the benefit of the system when a proper scalable utility takes over. I don't have
Okay,
the expertise and the staff I have to run the billing software, so it would be a struggle and would probably throw us back into one of those billing crises again.
and that was another question I was gonna ask you, because you have $69,184 for software and miscellaneous. Is that your billing software?
It's our billing software, and then some of our basic, Microsoft Office, et cetera, that we have internally. But the bulk of it is the billing software.
And it's still gonna be approximately that same amount of money next year?
Probably, yeah. I mean, this is one of the tricky things as a receiver. Yes, could it be done cheaper? No doubt, but it's. I hadn't planned to be in this case for 4 years, but it's one of those things. It's less disruptive to the customers, even though it's basically eating up the creditor's money or the system's money, to not cause those changes and only do it one time when you sell an operating business like this.
Okay. Oh, and where, if I wanted to know which category that the outside contract billing is being done, is that in contract labor or is that in accounting?
No, again, accounting, we use an outside accounting firm. So that would be accounting.
What are they accounting?
Well, we have all of our, they handle all of our payables, they handle payroll, they handle, our tax reporting, and the billing company is basically managing the billing process, and the, customer facing side of that.
Okay, so which category is billing in? Is that under payroll?
No, well, the payroll for our people is under payroll, the people on our payroll, but the rest of it is going to be under
Contract labor?
probably, yes, because there is a contract labor component to that. There's the billing company, the billing software is called Eldorado, and the vendor who works with us on it is called Creative Technologies, and they're going to be under the contract labor piece, I believe.
Okay. Oh, and I forgot to ask, and I couldn't remember, I thought I remembered reading in your testimony that like your employees that go out in the field are having to use their own vehicles?
Yep, we've not been able to, we've had times where we've had every vehicle the company owns, all three of them have been out of service. So we have, unfortunately had to pay employees for the use of their trucks.
So AV Water doesn't own any vehicles or any equipment?
No, it owns some. It's a question of whether it's working at that point, and we have the
Okay,
repair it.
okay,
Again, the priority is, repairs on the system first, and then repairs on equipment as there's cash available.
okay. On here, on your schedule, corrected schedule A1, you listed 3 adjustments, 3 revenue adjustments. And the 106,907, is that the overbilling?
Yes, ma'am.
Then the 37,082 to the city of Farmington, that's because you've paid up the arrearage?
Yeah, that would be the
Okay.
amount that we would pay over the actual bill. So
Okay.
we're showing that it's dropped off.
And then you're also showing an $80,000 depreciation expense?
Yeah, that is our sort of best guess. Under the prior orders, I think it was 127 or 130 in depreciation expenses. Since we didn't have a lot of that equipment, we did our best to come up with an estimate of what the current remaining assets were depreciating at.
And you're not specifically referring to those 4, or let me ask you this. What assets are you still depreciating?
Well, the 4 that you've identified, plus clearly all the ones that I swept up in the system assets, the hydrants, others. We don't have the engineering studies to actually do this correctly. So we did our best to come up with an estimate based on what the prior numbers were and what we thought was a fair estimate of where we were.
And I can tell you from doing the last case, even when you have engineering studies, it's still difficult when you have no original cost to estimate that. I just made a note on that 80 because I thought I read somewhere in your testimony that you weren't going to claim any depreciation. So
Claim any return on equity, but we thought it was better to make sure that we had marked something for depreciation.
okay. Yeah, I know in H7 you had 80. Okay. What level are the two operators that you have?
Both of the two that I have today, well, I have 3 people working in the field. One is not yet sat for his level 1. The other 2 are level 1s, and I'm pushing the senior of those hard to go get his level 2. I think he might actually do that in the next 60 days or so.
Okay. You haven't filed an annual report with the commission since you've been receiver?
I have not. We have not had the funds to do it. We are in the process now of we've hired Elizabeth Johns, an accountant with experience and is known to the staff, and she has tackled that project of bringing us forward to current.
Again, in my previous experience with AV Water, they were leasing part of a building owned by an affiliate. However, it looks like that what I was able to glean from your testimony, that the office for AV Water is now in the city of Farmington. Is that correct?
No, we're still occupying that same building. We just pay rent only as there is cash available in my hierarchy of needs. They get periodic payments when there is some surplus cash. But because they are an affiliate and because as a receiver, I can treat a landlord like that as an administrative expense, they will get some payment for the use of their building in the final accounting of the receivership.
Okay. Are they in category 1, 2, or 3?
2.
Okay.
But they're, as they would tell you, they are frequently at the bottom of the 2 category.
and do you know whether or not the affiliate is still occupying the building?
There's no other, we are the only occupants of the building. All other of their related entities have gone away. So
Okay.
the owner of the building is an affiliate of Mr. Upenlatz.
And looking at your RADA testimony, Lewis Exhibit 2, again, I think as we've already set forth in the record, on page 1 of that, you describe that this testimony is to provide corrections to the original application and testimony because of the inadvertent over collection from 2 commercial customers in the amount of 106,907. Is that correct, sir?
Yes, ma'am.
And therefore the corrected 2019 revenue is 1,636,493. Correct?
Yes, ma'am.
Or
Wait,
that's what it was. Well, no, that's the corrected, I guess. Okay.
yeah, the corrected number, I believe, is in the 2019 was 1,529,586.
Okay. And I believe you've already testified as to how that's being dealt with. And then your supplemental testimony. You're addressing circumstances that happened after the last stipulation. Including, as you say on page 7 of your supplemental testimony, these particular more details, including the ownership and current status of water rights, status of short-term loan, AV rates and interval between rate cases, system improvements and capital expenditures, depreciation study, and coordination with staff, correct?
Yes, those were all items that staff or mediator Glick had asked about and asked me to report back on.
And it's my understanding that potentially either what helped lead to the receivership or a case that was merged with the receivership is that Andrea Corp is attempting foreclosure on the water rights.
Yes, they attempted to initiate a separate action, or they successfully initiated that action. But the receivership order is very specific that says that no creditor may act against assets of the estate without the supervising court's permission. And they did not request that permission. And those water rights are, as we've discussed, are obviously integral to the case. And Andrea Corp was well on notice that the case was pending. They had a copy of the receivership order. So the subsequent judge on the water right foreclosure ultimately transferred that case to the judge that is supervising me. We have a number of legal issues there that are briefed and waiting decision. Everybody, of course, is watching with interest to see how this rate case goes and whether or not the creditors are actively working on settling claims amongst themselves as to whether they can resolve the need for that foreclosure.
Okay. Well, when you are negotiating a sale, as the receiver, do you negotiate also with the creditors?
It depends on the case. In this case, I am really bringing to the court a disposition of the assets. and suggesting to the court that they take the money in and request, in bankruptcy court, we can actually order this, but in state court, request the creditors to transfer their liens from the physical assets that they may have to the proceeds. And then the court will determine the extent, interest, and validity of their claims in those proceeds and divide them up. And that's an end of a receivership kind of action. So we're kind of right at the cusp of that with the Andrea Corp foreclosure. We're trying to get everybody to sort of stay focused on the goal, which is to get the company to be the operating assets to be sold out of receivership and placed in the hands of a real operator. And then let the court do what the court does best, which is to resolve claims to money, and get these customers and this water system separated from that discussion. And so we're sitting right at that place.
Okay. And then further on in your testimony, your supplemental testimony, you're at page 12, you're referring to the current rates and making the observation that the current rates are, as you put it, now 11 years out of date. That's correct?
Yeah, that's what I've said in there.
Okay, so what is it you mean by that?
Well, I feel a little bit silly answering this to you who handled this case, but the rates that we're currently operating on were as of sort of 2009. A 2009 timeframe. There were some minor modifications of that, but in effect, the same rates have been in effect on the system since 2009. And so they haven't adjusted for inflation, and which is, a minor problem, but I also think they don't really reflect the way they're not well tailored to the customers. There are a number of sort of issues about them.
And do you also understand that just like this stipulation that's being offered, those ultimately were stipulated rates?
Yep, I do. And I wonder what was going on in everybody's head, but I can't go back and examine them on that topic.
Uh-huh.
I wish.
Well, I suppose it's appropriate for the West, although I grew up in the Midwest. As my grandmother used to say, if wishes were horses, we'd all take a ride. Okay, so now let's look at your testimony in support of the stipulation. And again, my understanding is that based on your testimony and the staff and Mr. Key's testimony is that the parties came together and used their best efforts and came up with this stipulation that varies from your application as corrected. Is that correct, Mr. Lewis?
Is correct.
And I had hoped to find some explanation in the testimony, and I really didn't find what I was looking for. So I'm going to ask you, rather than sticking with the more common either way to increase revenue or increase rates by increasing the either the customer charge or the commodity charge or both, which is what you had proposed in your 27% request. In the stipulation, you've changed it, correct?
Yes, we did.
And essentially, you've dropped your request to include the customer charge, to increase it by 27%. And what you're left with is some type of increase on your commodity charge, correct?
Yes, with
And it's not the straight 27% anymore, is it?
no.
And is there any schedule or part of your testimony that will tell me for each of the commodity structures what your percentage of increase is?
That's a good question. I may have to ask for help from everyone else. But if I may back up a little bit and kind of explain what all of us were attempting to do here.
And I just want to set the stage here with just laying out in the record. I think I've laid out what originally you wanted to do, and now I'm just trying to lay out, in essence, what you've done.
Okay.
Okay. So while you're looking for that, the other change that was made in the stipulation rate design is that you're asking for a new charge to be implemented called a repair and replacement charge, and that amount would be assessed on a monthly basis in the same amount to all three of your customer categories, correct?
Correct.
Okay. So did you find any schedule either attached to your testimony or the stipulation that's going to provide me the percentage of increase on your commodity rate?
I believe we need to look at stipulation exhibit C. It is to it's a large amount of numbers on a piece of paper, so it's going to be difficult to read. If it would help, I would offer to share the image of it that I have on my screen and try and blow it up so everybody can see it, if that would be useful.
Okay.
Am I permitted? I need you or Anna to permit me to share my screen so that I can do that for you. No, no, you're sharing your screen. That's not quite what we need.
Nope. And you don't want to see that one, and you don't want to see that one.
So I think what you need to do is stop the screen share and then permit the little arrow next to the screen share on your screen will allow you to allow other participants to share. And that's what we need here.
Okay, stop the share and then,
If you look at the green screen share button at the bottom, I think there's a menu right next to it. There should be a little caret menu thing, and I think you can then enable participant sharing. No. All right.
new-
Sorry, then that's,
I think maybe
No.
you can do it under manage participants. If you go over to your participant list, it'll say more. I think that you may be able to do it that way.
oh, that's a good idea. Thank you.
well, my little participant screen is not,
So what we can do, I will email you the PDF file right now, and then you can put it up on your screen share if that's acceptable.
okay, like I say, I have it here in my notebook.
Everybody, all the participants in the stipulation have it. It's like I say, it's just a big image.
Yeah. And ultimately, what I'm looking for, Mr. Lewis, is the ability to compare again where we were to what
Is proposed.
exactly. So like, you know, I made all kinds of little drawings like this for myself. And I still don't have it captured. But one of the things that you did in the notice that I think really makes it concrete, and when I write this up and when I have to go before the commission and I have to say to them, here's what they've asked for, and they go 27%, you know, then I'm able to say, well, actually, in their 3 categories of customers, their average residential customer who uses X gallons of water per month would see an X dollar increase, and that would be, you know, over the year, it would be, you know, X number. So, and you did that in the notice, right? I mean, you said for the residential customer, you know, who uses approximately 5,000 gallons, that, you know, that their increase, I think was going to be something like $140, $161, something like that. And you did that for each category of customer. But now with your changed rate design, I don't have that information. And I want that information. And if you have not provided me with that information, then please consider it a bench request that you, along with staff and and Stonetown and the Northrops get together and provide me with that, because I want to see it.
Well, understandably so. Stipulation Exhibit C provides that information, and I've just emailed to everyone that I can see here on Zoom the image file that I'm looking at, because it's from a spreadsheet, and it shows our present tiered billing, the proposed stipulation billing, and then where those rate increases fall, and the with and without the R&R charge. So what we tried to do, the R&R charge is 77% of the rate increase. And then what we tried to do was appropriately redesign the commodity charges. One of the things we discovered as we really dug into it, and this is where Karen Northrop smacked me on the head one day, was that we were charging $1 for 3,000 gallons that we were paying, $6.75 for. And so by adjusting, leaving the monthly charge, the base charge fixed, fixing that subsidy that was being transferred to the higher use customers for the 0 to 3,000 and adjusting that category a little bit, then we were able to spread the balance, the 23% of the rate increase across the tiers, adjusting to ensure that high users were paying the most money. So that stipulation exhibit C gives you that information. Hopefully you can blow it up on your screen, which you can't really do on paper, and start to see some of that information.
Well, for some reason, my Adobe is,
Resisting.
I don't know what its issue is. But
Madam Hearing Examiner?
hi, Ms. Drake.
Hi there. If I could just clarify, I understand you've issued a bench request to AVW. Just based on the information I think all of us have, I think Mr. Lewis may not realize it, but I think he has that bill impact information that you're looking for. So
Okay.
if I could suggest to you that maybe that Mr. Bogatko and Ms. Northrop and I coordinate with Mr. Lewis, and because I think he has that information that he can get you in a bench request response.
Okay, and that's what I was suggesting, that you all get together and come up with something, because that if you all work on it together, then that avoids potentially anybody not being happy with that. So Mr. Lewis, if I'm understanding what you've told me so far with this rate design, have you done any designing of rates before?
No, not me. I relied heavily on the help of Ms. Drake, who's an expert in this, as well as the staff. We talked all of this through amongst the mediation participants. And
okay, so you're saying that somehow, rather than keeping what you proposed, that you decided a separate charge would be appropriate, and then somehow came up with the separate charge should be 77% of the revenue increase. Is that correct?
Well, it wasn't quite that out of the air. The $14 charge mimics the R&R charge, mimics what the city of Farmington charges its customers. One of the interveners' issues, as I said at my opening, was they didn't like the fact that our rate structure was different or substantially different from the city of Farmington's, because it made it hard in the purchase of sale of their properties and explaining, you know, where they lived. So one of the things that they brought to the mediation was we would like the tiers and the structure to be similar to the cities, because people in this system feel like they are an extension of the city.
But they're not,
They're not.
are they?
No, they're not.
And
But
the city of Farmington did not purchase AV Water, did they?
they did not. They have no interest in that.
Uh-huh.
But the interveners were interested in, could we, you know, come to a system that was similar? And, you know, I will confess, it took Karen several tries to get me to understand what she was saying. But ultimately, once we understood the R&R charge, and then the charge for applied to that first, the 0 to 3,000 tier, all of a sudden it was very doable to achieve what we needed, the additional revenue. We like the R&R charge because it approximates that 300,000 a year we're currently spending on trying to keep the system together. It ushers the customers that the money they're paying is going to that purpose and not subject to diversion. And then the rest of the tiers was basically aligning commission policy on high users paying more, and ensuring that sort of the burden was fairly shared across everyone.
So you like that charge because it approximates what was being spent. It also
Dedicates.
allocates the charge for what it's supposed to be. And was there a third reason?
Well, and the third reason is then when we liked the charge because it basically funds what we're spending now. It's segregated. We agreed
Right.
to the community, to our customers, what we were doing with it.
Okay.
And then that permitted, you know, once we solved that problem, the remaining 23% of the increase, you know, that R&R charge is 77% of it. The remaining 23% was readily addressed by changing the 0 to 3,000 tier from one to not be subsidizing, be subsidized. So it's a straight charge of what we pay the city of Farmington, people will pay us for that category. And then the balance was staggered, tiered to reflect commission policy to, you know, promote conservation. It's not too much more scientific than that, I'm afraid.
Well, and one of the big things about an upfront collection charge like this, whether it be a increase in a customer charge or a separate charge, it gets the company the money faster, doesn't it?
Well, to me, it does two good things. One is it provides a consistent source of funds. You know, it'll take some time to build that R&R budget up, but at least we can charge repairs to something and track it and show the customers what we're doing, as opposed to just scrambling. The second thing it does is the customer concerns about the history of AV water, which is that they would say that they were going to do something like this and the money ended up elsewhere. And that's a fair criticism based on my understanding of the history. So if we can solve each other's problems, they have a vested interest in seeing us repairing the system. And so based on the mediation discussions, we're all quickly able to sort of come to alignment that this was good for everybody. And it was
Okay.
usage driven.
And then I note that, you know, in the testimony, and just now in your testimony, you allude to increasing block rates on commodity charges as being tied to conservation, in that allegedly, if people have to pay more, they're going to use less. Is that correct?
That was our hope.
But in essence, you're reducing the current commodity rates with this rate design from what's being charged now, aren't you?
Well, we're changing it.
Well, let's just look at it. I mean,
Sure.
if you look at the 0 to 3,000, that's increasing. You're going from $1
The two,
to 275, correct?
right, to match the exact cost of the city of Farmington, plus a little bit.
But I thought I heard you say that it's costing AV Water $6.75 for each of those first 3,000 gallons.
Right, we've reduced that subsidy by, we got $1 for those 3,000 gallons.
Right.
Now we're getting $2.75. Let me check my chart here, per thousand. So we're getting the $6.75 for that tier.
Well, in addition to the I mean, is the only cost that's included in that the $2.29 per 1,000 gallons?
I think so.
No, that's less. Well,
Per $2.29 per thousand, which is what we pay Farmington, and that's
right.
basically what we're asking the customers to pay past.
Okay, on the commodity, there's no other embedded cost in that.
No,
Okay, and then under your second tier, which is over 3,000 to 8,000, currently, it's a 602 per 1,000 gallons, correct?
hang on, I gotta find that. This is where I get lost in the numbers. I believe that's correct, but I'm struggling to find the rate.
Well, I think the easiest place for you to find it is in the notice.
Okay.
If you look on the notice at page 4, just under the block, usage charge 0 to 3,000 is $1, 3 to 8 is 6.02, over 8 is 808.
Yes.
Okay.
Nice.
So originally, under the 3 to 8, you wanted to go from 602 to 765, but in the stipulation, you actually reduce it $2.02 to say $4, correct?
Yeah, I think that was part of our discussion with the interveners, that the average customer sort of used, you know, around 5,000 gallons. And so
Right?
we were trying to make in effect, the first two tiers, I don't know, not more affordable, but with less of a jarring tier jump in that second tier, and then push the conservation efforts into the following ones, a higher.
Yeah.
I'm not sure we did it perfectly. I just, you know, we were struggling to try and treat people the way they asked to be treated.
And again, Mr. Lewis, you know, all I'm trying to do is understand the nature of your rate design. And again, you know, typically, yes, your rate structure might be an inverted block in your proposed rates and that it goes higher. But, you know, if you go on to your next tier, the original cost for over 8,000 per 1,000 gallons was 808. Now you want to charge $5.50, correct?
Yes.
And then now you've created a new category of commodity, the 9 to 20. Is that correct?
I believe so, yes.
And you've created an over 20 category, correct?
Correct.
Okay. And both of those numbers are also higher, correct?
Yes, I believe so.
Okay. So again, and maybe now is a good time to break for lunch, because I'm not sure I understood Ms. Drake in that you want to all help create the information, or you think the information is already in the record, Ms. Drake?
I'm not sure that the information in the form that you're asking for is in the record. And let me make sure I understand what you're asking for. My understanding is that you're asking for a bill impact analysis that shows for each of the 3 classes, the average customer usage, the current monthly bill that they would pay for the average customer, and then what they would pay under the proposed stipulated rates. And then you'd like the dollar change on that and the percent change so that you can see how that's changing per class.
Right. And basically what I want is something that is very similar to page 4 of the notice.
Okay.
And page 4 of the notice has the little chart, and it has the base charge, and then it has the different commodity numbers, and it says the present charge, the proposed charge, and the amount of difference and the percentage of difference.
Right.
And then the verbiage of that I showed you my little chart that I was trying to come up with. So basically it begins on page 2 of the notice, and it says, with whatever the percentage of increase for the residential class, there would be the system charge, which stays the same, the commodity charge would increase based on the table. The average residential customer uses 4,976 gallons, would see a total annual increase of $141. And then we did the same with multifamily and commercial. So I just want to be able to see what the impact is at the various usage rates. And I want to know how, so that I can represent it to the commissioners. Here's the average customer. Now, obviously, and I don't know what the breakdown, you can tell me perhaps, Mr. Lewis. I'm assuming the majority of your customers are residential, fall into the residential category, correct?
The vast majority, yes.
And then you've got some multifamily customers, and then you have some commercial customers, right?
Right.
And like I say, and then the verbiage was included with that. I mean, just for example, with my trying to figure it out on my own here, which I probably shouldn't have written notes all around it because now I'm having trouble reading it. But as I just said, you know, you were talking about a total annual increase of $141 for that customer under the prior request. When I just tried to figure it out myself, for a 5,000 gallon a month customer, I believe I think I came up with $174.12. If I'm picking the right number here. Okay, so that's the kind of thing I want. Okay, and then I think I actually came out with a decrease for multifamily. Customers.
Well, if it's okay with you over the lunch break, maybe we can, you know, some of us can
Okay.
work on this a little bit and
Okay,
help
okay,
this up.
okay, and that's, you know, I'm sorry, Ms. Drake.
I just want to be clear that we all are going to be coordinating on the right numbers for you. So do you want this
Okay.
on annual or monthly basis or both?
Both.
Both. Okay, thank you.
Both. People like to know how it's going to affect them, you know, saying $200 is not going to, you know, but if you know, that might mean one thing to one person, but if you say, oh, it's going to be $14 more a month. Well, okay. Okay. Well, with that, I'm going to have a few more questions for you, sir. But maybe if we can get some numbers here to look at so that you can just show me, I mean, that's pretty clear that the way that you did it before, 27% on everything, you know, what that was. And I'm just trying to figure out what this is. I believe that your testimony has been very helpful to me to explain where that R&R charge comes from, why you thought it was important in making the agreement, and then we'll talk a little bit more about the 23% allocation after that. or after the luncheon break. Okay. With that, unless anyone has any questions, I have that it's 10 after. Shall we come back at 1:15 and resume?
Could I ask, just so we can all coordinate with Mr. Lewis on this, and I'm not sure how quickly he can pull the formatting and the numbers together for you. Could we come back at 1:30, just to have a little bit more time to work with him
Okay.
on that? Okay, thank you,
Okay.
ma'am.
All right, we'll
Ms.
come back
Hurst.
at 1:30.
Ms. Hurst.
Thank you very much, and we're recessed until then.
Ms. Hurst. If we disconnect the Zoom meeting right now to start a new one after, we're gonna just lose the YouTube web stream. So
So just
Do you want to
keep,
just keep it up?
we have to, if not, we're gonna have to do it all over again.
Okay, no, we can just keep it up. As I've told people, the audio and the video both continue on unless we turn it off. So we're just gonna keep it on. I mean, is there any downside to leaving it on?
That is recommended by our IT department.
Okay,
So the parties can turn off their cameras and their microphones so that they're
Okay.
not being recorded. Uh-huh.
okay. Miss Northrup, did you want to say something?
Well, I'm just curious, do I hang up my phone and then call back, or do I need to keep it on this call the whole time?
No, you can call back.
I can hang up and call back. Okay.
Uh-huh.
And then is Randy setting up a Zoom conference, or how do we get involved with him through the lunch break?
Karen, we haven't gotten quite that far. I think with Zoom staying on, we'll probably have to do a voice conference. And so I'll send something around to everybody, or borrow somebody's conference line, and we'll get it out to everybody quickly.
Okay, perfect. Thanks, Randy.
Okay.
Thanks,
Thank
Elizabeth.
you all, and we're recessed till 1:30.
Did you call me?
Yes, I
Okay.
did. I just wanted to see how you thought things were going.
Well, I have to be honest, I was disappearing for extensive periods of time to attend other business. So,
Uh-huh.
but what I saw is this is going smoothly.
Um, all five of his exhibits were admitted.
hmm
Uh,
Remember, this is
so,
being recorded, so
okay. So
we can
you
talk about
can,
that later.
okay,
Oh, so I can send this exhibits to Melissa via email, right?
right, the five, yeah, I mean, if you want to send the five now,
Oh, okay.
yeah, just make sure you send her the revised number 3,
Okay.
okay? Because we're still on the first witness,
How many more witnesses you have?
4,
Okay. You think it's gonna
but
go
the
beyond
majority of
today?
yeah, the majority of questions are for this witness,
Oh, okay.
okay?
So he's presenting 4 exhibits. All right, let's see.
He has
1,
4,
2, 3, and 4. Okay, and those
right,
are the
but
ones you want me to send. And the one that we discussed last time, right? That had
right, the
modification.
number 3.
Mm-hmm. All
But then
right.
he also has the another exhibit that's called the signatories exhibit 1, and that's the stipulation,
Okay.
okay?
Anna, when you send me
Yes.
that email, hi, when you send me that email of exhibits, would you mind typing in the interveners' names just so I have their correct spelling? And also, was it Mr. Uperland?
Upenlat, I'll
Yeah,
spell it for you.
okay.
Okay. Sure.
Thank you so much.
Mhm.
Melissa, do you have your direct email or do I send it to Ivora?
Send it to my direct email. It's melissa@kendrareporting.com.
Okay. Thanks.
Thank you.
It's IUPPENLATZ.
Oh, I'm so glad you spelled that for me. Thank you.
Okay,
Thank you so much.
and then Eckert was ECKERT.
Excellent. Thank you.
Okay,
Mhm.
okay.
Oh, also hearing examiner, was it Andrea Corp, C-O-R-P? That had the lien or the mortgage?
Yeah, short for corporation.
Okay, I thought so. I just wanted to be sure.
Okay. Uh-huh.
So Melissa, I have another email address here that says melissa.vhill. Is that the one? Or that-
No, that's a different email address that I have. It's Melissa, just my first name, @kendrareporting.com.
Okay, good.
Oh, I just need to grab my water.
Okay. Mhm. Can you see the screen?
Yes.
It's, it's, um,
Small and blurry though.
it's very blurry.
Really?
Yeah.
Can you enlarge it to fill your whole screen?
Maybe. Did that help?
Mm-mm,
Nope.
No.
Huh, bummer. Okay. Well, that's too bad because I actually was able to pull up that Adobe and screen share that. So wonder why it's small and blurry because it's on my big monitor.
I suspect what it is when you, on screen sharing, we have this, we teach our classes at the university on Zoom, and screen share gives you all these different options of desktop and then each specific application. And
Uh-huh.
you have to pick the, so the one that doesn't look like your desktop with the document on it, you have to actually pick the application and share that one. And that should be the high resolution version. I know, modern life as we all live it now.
Yeah, I thought it was a big deal to have two monitors. Woo!
Yeah.
Not so much, I guess. Okay, well, so it looks like we have everybody except the Northrops.
Right, and they were gonna dial back in.
Okay. Okay, well,
there they
oh,
are.
there they are. Okay. I think we have everybody. Melissa, are we ready?
Yes, ma'am.
Okay. All right. Well, we're back from our luncheon recess and we're going to continue asking Mr. Lewis some questions. Mr. Lewis, were you and the parties able to come up with the information that I would like to have?
Yes, I believe we were. I wanted to ask how, we have sort of a draft response to your bench request, but I was uncertain about process here. Do you, everybody who's on the phone with us has seen it. We haven't obviously sent it to you yet. Do you
Okay.
want to send that to you?
You want to just read it to me?
I can sort of by class and
Okay.
okay. So what we did was we tried to compare the across the board flat 27% with the proposed stipulated rate increases. Okay, so I'll read you what we did in each class with the across the board and the stipulated rates. Okay, does that make sense?
What I want is the difference between the original rate and the stipulated rate.
Okay, that I can do, but it's a little bit harder. All right, for the residential rate, their current, based on a 5,000 or 4,976 gallons, which is the exact number.
Okay.
Their current Customer charge is $30.70.
Uh-huh.
Their 0 to 3,000 charge is $1.
Uh-huh.
Their 3,001 to 8,000 is $12.04.
Okay, I just want their monthly bill.
On their monthly bill. Okay, so that works out to $46.68.
Okay,
Okay, and under the stipulated rate increase, their monthly bill goes to $65.13.
okay,
Okay, which is largely comprised of the R&R charge of $14.10 and the charge, the $8.25 charge in the 0 to 3,000 range.
okay.
Okay.
Uh-huh.
With the commercial users, multifamily was my next one. The average usage is 12,571.
Okay,
I believe we have 17 or 18 of these people. Not a whole lot. So now let's see if I can do this. Their basic number would remain the same. The minimum system charge is $72. They get charged the repair and replacement cost of $14.10. And then the average user would actually see a decrease of $2.18 per month.
okay, so what were they paying before?
I can't see it. So they were paying, hang on, I've got it. Let me just find that document. They were paying before. Okay. They were paying oh, crap, I'm not finding that. I'm sorry, I don't have what they were paying before right where I thought it was.
Okay, what are they paying now?
Under the stipulation, they would be paying, well, I can see why this is confusing both of us because I don't have the right numbers. It's a decrease of $2 per month, but I don't know what the decrease is from. Hang on, let me ask. Because the chart I'm looking at has just the residential people and I can't find my other one. Give me a minute, please.
Well, I just have your stipulation exhibit C, page 2.
On page 2.
Actually, I guess it's 3. It has the multifamily. But I have them between I don't have specifically for 12.5. I have 10 and I have 15.
Yep. So, so the multifamily goes from 149.22 to 147.04 for 12,571.
Okay, 149.20,
2
okay,
to 147.04.
04,
Yes.
okay?
Okay.
So there's actually a decrease under the proposed rate design.
Yeah, and one of the things that we want to point out is that class where the multifamily users mostly sit sort of in the 11,000 to 30,000 range was the class that was the sort of range of rates that was subsidizing the low end users. And so this is where there's when we redid the tiers, the blocks, this area was very high on the previous structure and is showing a decrease, but it's still in sort of a linear increase when you look across all the models. So let me just finish and give you the commercial one.
Okay.
We have about 45 commercial users. We have several huge users, so the average is somewhat crazy. It's 70,000 gallons is the average.
Yep.
So then they would continue to pay their base rate of $41.20, get the 1410 charge, and their would see an increase of $66.38 per month, or a total of $796.51 per year, and their original numbers are
It's like 2,000, wouldn't it?
So they're the commercial customer at 70,000. Their monthly was $610.87.
Right. And did you have the increase for the multifamily?
Yes. Well, the multifamily is a decrease of $26 per year.
Per year?
Yeah.
And the annual for the residential family?
The annual for the residential family would be $141.
Okay.
You know,
anything else you want to tell me about this rate design?
well, I think the biggest issue to try and emphasize is that, you know, by changing the heavy sort of, I don't know if you call it mid usage high charges to subsidize the low charges, you know, the structure, the old structure created a couple of perverse outcomes. One is Karen Northrup reminded me at the break, it was so heavily weighted, it forced a lot of people to wipe out their landscaping and over conserve, if you will, because as soon as they started crossing over the 3,000 gallon mark, that their rates jumped up so high that, you know, they went to xeriscape or no landscape. The second thing is, you know, we're trying to focus the bulk, the 77% of the increase of the whole 27% is in the R&R charge. You know, so that's something everybody in the system shares. So we're trying to break the intra-class subsidy. Then we're trying to get every user to pay for the repair and maintenance of the system. And then we want to make sure that the actual rates charged to the high users are high rates, so that, you know, it does in fact incent some level of conservation. I hope I got that right.
I think you did. If I understand what your testimony is. I just want to be sure that I understand with this new rate design that basically with the residential customers, even though you've restructured the commodity charge downward, you're still going to come out with the 141 annual increase that would have been proposed under the 27%. Is that correct?
Yes, I believe that is correct. Because, you know, I mean, if you, in simple math, the 60 non-residential customers, you know, we have basically 1,800, we'll do it in the simplest of math, 1,800 residential customers and 75 non-residential customers. So when we apply the cross the system R&R charges, that class is going to show the highest percentage of that. But by restructuring the classes, we're not continuing the almost what's the word I'm looking for? Almost the penalty against using any more water than 3,000 gallons that was embedded in this. They got the first 3,000 for free, and everything after that was super expensive.
Right.
And so there's just a weird impact that created.
And then the change in a multifamily where under your straight 27%, that would have been a $454
Increase.
Annual increase. Now it's going to be a $26 decrease, correct?
Yeah. Yes, because that $450 increase was really amplifying the you know, the backloading of the rates to those multifamily users, and not really, you know, putting it at the highest users in the high volume concrete facilities, et cetera, in the commercial users. So, you know, we think, you know, I'm sure we're not perfect with this, but we think that tier from 11,000 or so of gallons used was overcharged, and the bulk of the residential under 3,000 were being subsidized by that overcharge, and all of these things are leveling.
Well, I mean, if you look, for example, at your exhibit, C1, and you look at both the 2 and the 3 and the 3,000 gallon usage customer, which the cost is the same. And I guess I don't exactly know. I guess it's just the amount. I mean, if you look at the percentage of change for, for that low, I'll characterize them as a low user customer. They're getting the highest percentage of change, aren't they?
They are. But the averages aren't, I don't think are helping here.
Okay. I mean, I guess my point is this, Mr. Lewis. Don't you think potentially that, that's kind of going to be rate shock to that particular customer who was paying $33.85 a month to now all of a sudden they're going to get a 56.60 bill?
The answer is clearly the increase is significant. But again, the bulk of that increase is in the R&R charge, which they are sort of equal consumers of the system. That R&R charge goes to benefit every single customer somewhat on a flat basis. So yes, the gross amount of their bill from up to the $65 level or whatever it settles at is a big change for them. But we've changed the pricing in the tiers so that they're not, paying as much in usage charges and commodity charges. And so, the discussion among all of us was that we thought that was a workable outcome because the money was being put back largely into the system through the R&R charge.
Do you have any information on whether or not your low income customers are low water users?
I don't.
Do you have any information about whether or not your fixed income customers are low water users?
I do not.
Isn't it conceivable that these 3,000 gallon users might include low income and fixed income customers?
Yes, of course, it's very conceivable.
And don't you think that a $23 a month increase in their bill might affect them negatively?
I'm sure it will affect them.
Okay. Then finally, with your commercial group, under the proposed 27% increase, they were going to pay about $2,000 more a year, correct?
Under our proposed structure?
Under the 27%
Under the flat.
proposed structure. But yet under the stipulated structure, now it's going to be about $800. Is that correct?
I believe that is correct.
And so what is the explanation then for their $1,200 proposed increase? Do you believe that they were also, that these high water users were also subsidizing low use customers?
I believe that was the effect of the existing rate structure. I confess that we, in our efforts to, build a tiered usage structure, it may not be perfectly reflecting conservation goals with these people.
And as far as the other charges, Mr. Lewis, did you keep those at a flat 27%?
We were discussing that. I'm embarrassed to admit that we didn't discuss it excessively, but I think we basically have kept them flat at their current charges. Most of the revenue is embedded in the R&R charge.
So then are you saying, and I guess I did not, that was my assumption. I guess perhaps it's an incorrect assumption. I'm looking at your schedule N3 of your application, page 2 of 2, and
I'm sorry, we're back to the, I'm following where you are. I'm sorry.
oh, I'm just because it has a listing, I'm looking at your schedule N3 of your application,
Okay.
page 2 of 2, that has other charges. And I know that you had various other fees. And
Yes.
I know what they were originally, and I know what they were under the 27%. And
You don't know what they are now.
right, and that's what I'm asking you.
Well, I believe what we did, it didn't dawn on me until we were having this discussion prior to coming back from the break. But I believe we left those at the existing charges and did not increase them by the 27% because we had embedded the revenue that we needed in the charges in the 27%.
And can you point anywhere in your stipulation or your attachments to the stipulation where you address this?
I cannot, because to be honest, I'm not sure we did fully.
Okay. Why not?
I'm looking at our other charges sheets attached to the stipulation. So that's pages 5, 6, and 7. And I need to go back and see what they were originally.
And actually I have that on my sheet.
Thank you.
So but I don't know that they are. I don't know that they're characterized under the same verbiage.
Well, that's what I'm seeing too. So
Okay, well, you're gonna have to consider this a bench request too, then, parties. I gotta know what you're asking for, if you want me to recommend it. For example, I see new meter, 1,174.75. That's on page 5 of Exhibit D to the stipulation. I have that when you look at Schedule N3, page 2 of 2, meter hookup fee as being 1,174.75. So that would have been a 27% increase from the 925, which I believe was the original uh, 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 meter hookup fee. So if that's the same thing as a new meter, then that is an increase. Hookup or reconnection, I have 6350 as being the 27% increase, whereas the original, I believe, was 50. Meter testing fee also 44.45. I had that as being 35 under the original rates, rules, and forms. Service trip fees, this is page 6 of Exhibit D. Regular business hours, 25.40. Again, under Schedule N3, that would have been a 27% increase over the $20 service trip fee. The after hours at 38.10 was also listed on Schedule N3. And the original, I believe, was 30. And the insufficient check fee, non-sufficient funds listed here at 31% or 27% at 31.75, where the original was 25, has been increased over the 27%. I have no idea what percentage that is, but the insufficient check fee proposed by the parties is now 44.45. That's correct, Mr. Lewis?
That I'm following you as you're coming through the stipulation.
And I guess what I would refer you to I do not believe I do not see the rates, rules, and forms attached to the stipulation, but I can't tell you if I got those from going back and looking at the amended application that was filed. But again, parties are going to have to verify exactly what it is you're asking the commission to do with regard to these others.
Okay, if
Okay.
I think fortunately, these are not the guts of our revenue, but yes, I think we can go through and verify that and provide you a written answer to that.
Okay, so you're gonna have to verify, exactly what it is that you're asking the commission to increase these two and why. And then obviously the effect on your revenue numbers, if you haven't built those into your revenue numbers. I don't know, Mr. Bagatko, did staff address this? Unmute, yep.
I believe only peripherally, but probably not as directly and as in detail as it sounds like maybe we should have. So we can work with Mr. Lewis on responding to bench request number 2.
Okay, and what would, in both the one that you worked on today in written form and this bench request, what would be really nice is that if I got all 4 of the active parties to agree that, you know, that those were the answers and that you did not want to have an opportunity to challenge them or have a hearing on them.
Yes, Madam Mayor Examiner.
Okay, so if, you know, if no one's going to challenge them or wants to have a hearing on them, then I can go ahead and rely on them. And if not, then I'll have to set up a procedure to allow for challenge and a request for hearing if somebody makes one.
Yes, ma'am.
Okay. Okay. So we don't know yet on the others. And am I correct, Mr. Lewis, we don't know if those are flat 27% increases, how or if they were treated in the overall revenue requirement?
What I know is in the overall revenue requirement, they're a relatively small percentage of the total revenue. And so I can't be specific. I recall when we were first putting together the application, we were generally trying to follow the 27% unless we had specific information on what it was costing us for you know, something. So generally we were staying in the 27%, but you know, our system hasn't really been growing. So like new meter charges aren't a new hookups are not a big part of our revenue. And as we have moved to a credit card payment system, we've had a significant drop, which I think is a good thing, in return check charges. And, you know, so we've been working our way out of this line of revenue. These other fees are mostly designed to capture costs and not drive revenue.
I know you've testified earlier today that that there's a period of months that you weren't sending out bills.
That was pre-me in the end of 2016 and early 2017.
And I just wondered, do you have any issues with regarding collection of your bills?
Actually, we do really well. You know, we usually call every customer that's behind and talk to them. If they're having problems, we try and work out payment plans. And you know, if they are red tagged for some reason, they tend to pay up. We really have had very few, except with respect to 2 multifamily customers, we have very little collection issues.
In multifamily, what's the, I mean, I can read the definition that's on the, you know, that's on the the advice notice and rate sheet. It's more than 1 meter coming off the single line going to the property.
Well, it's more than one residence off of the, you know, off the property, or off, what am I trying to say? That, so you have 2 or more residences, whether it's an apartment complex or 2 dwelling units on a piece of property, that those are multifamily to us.
So, so then I'm incorrect that this is like a residence and a guest house.
Yeah, a guest house, I don't think we would treat as multifamily. I mean, if it, you know, we have a lot of manufactured homes in the system. So if there are two, a double and a single wide trailer with two families in them, that would clearly be multifamily to us. If we have very few, like 3 or 4, where there's a constructed, you know, like walk-up level apartments or shared wall apartments, you know, that's clearly a multifamily property to us.
That's not considered a commercial property?
No,
So somebody could have an apartment building with 16 families in it, and they're only gonna pay 1 meter charge?
no. Yes, they pay the higher base rate and 1, you know, R&R charge, and then it's all on usage. I mean,
Hmm.
the way the system has been set up, so.
Okay. Interesting. I note on Exhibit B to the stipulation, page 1 of 1, entitled Total Revenue Requirements by Rate Class, Test Year Period. There is a category called Revenue Requirement with Stipulated Rate Structure Proof of Revenue. Are you there?
I think so. Exhibit B, page 1. The stipulated rate structure.
Uh-huh. And the very first line, you have stipulated rate increase. And so you say that the total rate increase that you're still asking for, even under the stipulation, is 27%, correct?
Yeah, I'm not sure I'm seeing the line you're looking at. I'm sorry.
Okay. It's the 1, 2, 3, it's the 4th category down. Revenue requirement with stipulated rate structure, proof of revenue.
Yes,
And in that very first category, it says stipulated rate increase. And under the first column, it says total, and then under that, it says 27%.
yes, I see that. Okay, I'm sorry.
Okay. So, like I say, to me, that means that the effect of the stipulation is an agreement to increase revenue, the revenue requirement by 27%, correct?
Yes,
And then in the next 3 categories, you have down the effect of that 27% increase, correct?
yes, I believe that is correct.
And therefore, under this exhibit, what you are purporting to say is the residential revenue increase effect will be an increase of 30%. Correct?
Yes,
And commercial will be 18% increase, correct?
correct.
And then the multifamily will be 7%, correct?
Correct. Again, I just, without belaboring the point, we have so few, the bulk of our customers are in the first category and largely not in the other 2 categories. So,
Okay,
you
I
know,
understand.
the percentages are and the averages are skewing things a little bit, I think.
Okay. And like I say, I understand that. I'm just trying to understand your exhibits.
Yep.
And yes, I understand that. Yeah, certain things get skewed. And And, you know, until someone actually sees how it applies to them, you know, they may not,
fully appreciate the impact on them.
absolutely, you know, like that customer I was referring to, who's going to have a 63% increase in their bill. That's not 27%. They read the notice that they might be getting a 27% increase. You know, I think they're going to be surprised when they get a 63% increase in their bill.
Is a fair point.
From, you know, again, just looking at it from, you know, from all the different. Any speculation or thought when constructing these rates, Mr. Lewis, of, I mean, obviously, you've achieved a lot of positive things so far for this utility. And thank goodness for that. Thank goodness that the people are getting quality water and not having all of the issues that they had before. And one of the things that you've said in your testimony that you want to achieve, of course, is to make this a viable entity for sale, and you've got somebody that wants to buy the utility, correct?
Yes.
So, I mean, that it hasn't been, I understand it hasn't been achieved at this point, but I would have to think that you're probably feeling pretty positive at this point from where you were when you took over, correct?
It's been incredibly nerve-wracking. As I said, like when we had the overbilling hiccup, I mean, that caused immediate ripples through the system. And so, yes, I feel good about what we've accomplished. We're now to that place where this or some similar rate increase is just essential so that the thing, you know, doesn't convulse with every single problem. And I think you're thinking at this point that, you know, that everybody would probably benefit from having a public utility company who has a track record operating public utilities would be beneficial for all, correct? Yes, and the area where I'm particularly think the benefit is in their economies of scale. You know, it's in the ability to leverage licensed operators, to have a single billing system, to not have to outsource like I do. And there, I think, you know, that's where the real economic benefit is. You know, they can pay a reasonable price for the system, but our structural inefficiencies are their advantage.
Okay. No, I just wondered if you had any consideration for, you know, any longevity for this proposed rate scheme or the potential effect of a purchase might have on your stipulation.
Well, I can't obviously speak for the buyer, but, you know, I've talked to them at some length about it, and you know, they too are, they know that they can't proceed in our current situation because the revenue is just too thin. They have told us that they won't proceed if, you know, this rate case were to fail entirely. Because they're buying a loss-making machine at that point. And they would have to be in on, you know, some urgent basis trying to get it fixed. So while I'm not trying to carry their water uphill, I am trying to get the thing to sort of a reasonable state of affairs that any sort of reasonable utility would at least look at it seriously, and then be able to see those structural opportunities that we were just talking about as a way that they could preserve this stipulation for some time, but do better because they don't have to pay all of my outsourcing charges. They can load onto their systems that they're already invested in. And, you know, that creates some longevity. I'm, as we've already discussed, I'm far from an expert in these things. But I think that there's an opportunity for some longevity in that, but I don't know.
Okay, you know, and I think, you know, if you're familiar with the stipulation in the last case when they got the CCN, you know, part of the negotiating that went on and what was presented to the commission, for example, was a 2-year stay out provision from the company where they agreed not to come back for a period of time to ask that rates be reset. And so, are you familiar with that?
I am.
You know, and like I say, I just wondered if I did not see anything in this stipulation that would have any limitation on the time frame of this agreement.
That's true. You know, I mean, when we were pursuing the 7.9% option, we knew we'd have to come back again and again. Because with this one, like I say, I personally believe as a restructuring professional that there are opportunities here. You know, we've solved a lot of the quirky operating issues. So what I would think of as a capable professional public utility can build on what we've done and, you know, streamline. And I guess it's me speculating, but I wouldn't see a need to be back in 2021 or 2022 because they're going to absorb the system and sort it out and then figure out, you know, but they've got their return on equity issues that we aren't addressing here.
One question that I started and then I moved on to something else, and it had to do with your billing. And in the improvement that I believe you testified to, that you did not believe that a cycle, I think, had been missed in the past 8 months. Is that correct?
18
months. And I just wondered how that related to the part of the stipulation on item 6 of the stipulation, other service issues, and on page 6A about not meeting the bill time frame. Then there would have to be an average.
Yeah.
You're familiar with that?
Yes.
How likely do you think that that's going to happen based upon the procedures and the efficiencies that you now have in place?
I think it's extremely unlikely that it's going to happen. The intervener who raised this issue, you know, has a commercial business, and, you know, when we were being inconsistent in billing, it
Uh-huh.
affects her business, because
Okay,
you'd be, say at 40,000 gallons, and then she'd be at 70,000 gallons. And so her
Right.
cash flow was getting slammed back and forth, and
Yep.
it was killing her. And
Yep.
I think she raises a very fair point that the system should be obligated to absorb some of its own problems,
yes.
not punish the customer, which is how I viewed what was going on. So we tried to come up with the sort of the simplest risk sharing scenario we could come up with here. We didn't want to turn it into a 10-page formula.
Okay. Sir, in your testimony in support of the stipulation on page 12, there's a question posed at line 9 and 10. Does AV Water's current revenue cover its expenses and debt service? You begin your answer at line 11 through 16, talking about no, it doesn't. And you've indicated that the test year loss is 161,297. But if you add the debt service, it's 515,644, correct?
I believe so. I'm sorry, I was not as fast jumping to that exhibit.
I'm sorry,
I missed the page number on the exhibit.
12.
12, thank you.
And the question posed at lines 9 and 10.
Yes. So yes, I believe when we fully load, the debt, all the debt service, including principal and interest, it continues to operate at a loss. Again, this is the opportunity, if we can get this thing out of its current environment, we strip off the high interest costs of the short-term Stonetown debt that's become long-term, and the cost of the water rights. All of that is stripped away, and the basis in the assets is reset for the purchaser. In my way of looking at things, not necessarily how you guys do it.
And I guess I'm just trying to understand then if potentially at least some of that loss would be reduced by the increase.
Yes, very much so.
Not all of it, but some of it.
But what it allows us to do is pay the secured creditors current interest, so that they are not going backwards on their money. And it doesn't fully load the customers with this risk. The creditors are still taking their risk on the sale, but it puts them in a place where they can be more patient with us, because they're getting current money on current interest. And we're not paying past interest, we're not paying principal, but we are able to get them to be calm in terms of standing still. And because otherwise they're carrying the risk of loss, the loss of principal payments, and no interest payments. And so we borrow this concept from bankruptcy court, where if we can pay, in effect, a reasonable equivalent value for the use of their assets, their money, they will stand still. And the good news is, with the, Stonetown is a big piece of this, but everybody is willing to accept that concept. And so that gives us, this group here, and me in my efforts to close this buyer, time to get to that place where the assets transfer to the utility, to a new utility, and then all the parties can talk about or argue about how they're going to divide up the proceeds. But it doesn't bury the customer in that cost, because at some level that's too far. that's saying, let's make the customers pay for, you know, all of the sins of the past. And all we're saying is let's bring the system up to where it's achieved an economic equilibrium and allows us to pay current debt service without regard to past due interest, missed principal, or any of those other things. If we can achieve that, that helps in my supervisory case, in my receivership case, and I think makes the system, the revenue and the expenses of the system look more real. And then, in my opinion, it gives the potential purchaser just one more aspect of the whole that they can restructure to their benefit, eliminating the inefficiencies, including that current interest payment. Because what we teach our students, I'm a finance professor at the University of Denver, and water utilities have some of the lowest costs of capital, and this one doesn't, and it should, but it's all upside down and backwards.
Yeah.
And we need to get it where it's upside right and going forward again.
Perhaps you need to teach a special course on developer-owned utilities.
Well, it's a brief version, but yes, I have 2 metro districts that I'm about to take into bankruptcy court on this very issue. So.
I don't know about in Colorado, but we seem to have several developer-owned systems in New Mexico that have presented many challenges to not only the PRC, but the Environment Department and others.
Yeah, we have the environmental issues. Surely ours are not regulated by the Public Utility Commission in Colorado, but they are quasi-municipal entities, so they're regulated by the Department of Local Affairs. And it's an entire another conversation to talk about all the developers can do in that environment.
Well, let me go ahead. I have a couple more questions for you. And if you go to page 24 of your stipulation testimony, and you are answering the question posed on page 23, describe section 4 and their service issues. And on page 24 at line 15, you say, the third issue is regularity of flushing hydrants and lines on the system. And the signatories agree to consult with NMED to develop a policy. That's your testimony?
Yes, it is.
And so can you elaborate a bit more on this? I mean, are there concerns that it should be done more frequently or less frequently, or?
More frequently. It is, again, a product of the old treatment system. It had a propensity to move a fair amount of grit in the system. The filtration system was not that awesome. So early on, I mean, many of the dead-end line flush hydrants hadn't been exercised in years when I got there in 2018. So we started a program of slowly doing that, trying not to compound our water loss. But also the grit moved when we reversed the flow directions of the system. So a number of customers have, some more vociferously than others, have been upset by some of this. And, you know, it's, as one of the interveners who raised this issue said, you know, this would be a good, you know, think of it as a good neighbor kind of thing to do, to try and get all the crap out of the pipes on a more regular basis. So when, you know, the system shuts down, or when we end up moving a lot of water, we don't fill everybody's dishwasher with sand. And so it's just, you know, all they really asked is that we look into this. And know that, you know, there's more to be learned here. Our discussion with the interveners were, would we work at this and make it a more knowable policy? Then yeah, we'll get to it when we can get to it.
Okay. Finally, I believe, Mr. Lewis, on page 26 of your stipulation testimony, the question posed at line 7 and 8, do these provisions violate any important regulatory principle and practice? You answer on line 9, no, there is nothing unusual in these sections of the stipulation. And I'd like to know what you're basing that statement on.
That is, to the best of I've learned your system, consulting, you know, among the participants in the mediation. So both Ms. Drake and staff counsel have all been helpful to me in understanding that we weren't bending or breaking rules indiscriminately. So it is my understanding that we have done our best to meet the regulatory principles.
I guess I did have one more question. Do you know whether or not with the rates as stipulated and proposed in the stipulation, whether or not any of the rates are now offered below cost?
No, I think we fixed that. You know, that's our problem in the residential class.
Okay, very well. All right, Mr. Lewis, I appreciate your answering my questions. Is there anything that you would like to tell me that you haven't already told me, either in your written testimony, or is there something else that perhaps I didn't ask you, or that you wanted to elaborate on your answers to the questions I did ask you?
Sort of in reverse order, you know, I will work on these 2 bench requests that you've made to clarify.
Okay.
I regret that we created confusion there. I don't like that. So we will address that. Really, my main point here is among the things I do is mediate complex multi-party cases. And I will say this is one of the first cases I've been in as a mediator or a participant where the group of people who with interest came together as quickly as they did. Everybody contributed. No one was painful. And the support for me and what I was trying to accomplish from the Northrops, you know, yes, Karen smacked me on the head a few times, but you know, the point was that everybody, including, you know, when staff was trying to figure out what I was doing or what I hadn't done, you know, everybody worked hard to help solve this problem. So this is for me, this has been a remarkable experience to watch everybody come together to try and pull to a solution. So that's really my final comment on all this.
Very well. Thank you, sir. I will be sure and let the commission know your comments about the process. So now is the opportunity. Mr. and Ms. Northrup, do you have any questions for Mr. Lewis?
Myself off now. No, I don't have any questions for Randy because we've worked through this process for a year together, and I feel up to speed with everything. I do feel like I need to comment to you on some of the things you asked him.
And I'll give you a chance to do that later. Okay?
Okay. That's good. Thank you.
And just for your information, I can tell you personally to the parties who have participated in my hearings before know that in stipulations, sort of my attitude is you all know a lot more about the stipulation than I do because you've lived it. You all have worked through the questions and the issues. So that's why when I get the stipulation, I can read it and I can read your testimonies and I can read everything else. But I guess as it should be, the way the process is set up, I don't know the give and take that you all engaged in to come up with an agreement, to come up with this stipulation. I only know, and again, properly, I only know what's on the record and has been filed in this case because that's all I'm supposed to know. That's all I can make a legally and factually accurate decision on. So, and not supposed to be violating, or I don't want anybody to violate any confidential settlement negotiation that went on. So that just lets you know where I'm coming from. And
Yeah.
so Ms. Drake, do you have any questions for Mr. Lewis?
I did, but I think your questions cleared up all the clarifications I wanted to ask. So I don't have any questions for him at this time, but I would ask, I know all of us will work with Mr. Lewis to work on the bench request responses for you. When would you like those? Do you have a date in mind that you would like those by?
Well, again, I'm working on 2 RDs right now. So I say, and I've got a hearing next month. So I say get them in as soon as you can. I am hoping, again, with whatever my workload is and deadlines, I will work on this case as soon as practicable. I can tell you that I know that you all would like to have the decision yesterday. Obviously, that's not going to happen. And the sooner you get me documentation, then that's going to put me in a position to work on your case within the time constraints. Obviously, my goal is to have this case completed before the end of the year. And I'm really hoping that we're not going to use our extension into February. Again, because I'm sure everyone would like to have that done. So as soon as practicable.
Okay, great,
Okay.
thank you. And I'd like to extend the offer now. I know we usually wait to address this at the end of the hearing, but I know you're very busy at this point. And so I'll just extend the offer on behalf of everyone that we'd be happy to draft and file and submit to you a joint proposed certification, if that would be helpful, given your workload.
And if parties want, and we usually do take that up at the end of the hearing, and obviously I don't believe that there's any, at this point, I don't see any legal issues that have to be briefed. And if parties want to submit some kind of joint proposal, that's up to the parties. If they want to do that, that would be fine with me. Okay.
Thank you. We'll try to work on that. Thank you, ma'am.
Okay, very well, Ms. Drake. Mr. Bradco,
Madam Hearing
any
Examiner,
questions from staff?
no, I believe Mr. Lewis has said more than a mouthful, and I'm going to let him go. Thank you, though.
Set me free. Okay, Mr. Lewis, again, thank you. And if there's nothing further from you, we can go on to Ms. Drake. And Ms. Drake, you have a witness. So Melissa, if we could swear in Mr. Key. Go ahead,
Mr.
Miss.
Mr. Key, can you swear I'm sorry, can you raise your right hand, please? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And I have this as well. I could send you an image of it later, but let me know if you need a copy. I'd be happy to email
I think we're fine with that.
it. Okay.
Okay, good afternoon, Mr. Key. Could you please state your full name for the record?
Maxwell Key.
And could you please identify the document that I've labeled as Stonetown Exhibit 1? Could you identify what that is, please?
That is my direct testimony in support of the uncontested stipulation.
And that is dated what date?
September 4th, 2020.
Okay. And was that testimony prepared by you or under your supervision and control?
Yes,
All right. And do you have any corrections to that testimony?
I don't.
And are your answers to that testimony true and correct to the best of your knowledge and understanding?
They are.
And if I asked you the same questions today, would your answers be the same?
They would.
Madam Hearing Examiner, I move admission of Stonetown Exhibit 1.
Any objection to what's been identified as Stonetown Exhibit 1, the pre-filed direct testimony in support of the stipulation of Mr. Key? Hearing no objection, Stonetown Exhibit 1 is admitted. Ms.
Thank
Drake?
you, ma'am. And I pass the witness for cross-exam.
Very well. Mr. Lewis, do you have any questions for Mr. Key? Got to unmute yourself.
There we go. No, I have none. Thank you.
Very well. Ms. Northrup, or Mr. Northrup, any questions for Mr. Key?
No, I don't have any questions. Thank you.
Uh-huh. Okay. Mr. Baracco, any questions from staff?
No questions for Mr. Key. Thank you, though.
Okay. Good afternoon, Mr. Key.
Afternoon.
How are you?
I am well.
Mr. Key, I know it says you are the vice president at Stonetown Capital. And your business address is in Colorado, correct?
That's right.
Were you part of the original loan to AV Land and Water?
Yes. So I've been in Stonetown for about 7 years, and I was here when that loan was initiated.
And have you had what experience or education have you had in public utilities or dealings with public utilities before?
As it pertains to public utilities, not a lot. I'm almost entirely on this system and relative to this loan. As a little bit of background, I have a bachelor's degree and also an MBA from the University of Colorado. I worked at Wells Fargo for 3 years in a commercial lending group. I have started one company that I continue to be involved in, and I've done a lot of work on buying and selling real estate, and also just participating in structuring transactions.
Okay. And is Stonetown a privately held company?
It is, yes.
And it's not not affiliated with AV Land and Water, is it?
No, it is not.
And none of, or any affiliate of AV Land and Water?
No.
And I find it interesting, Mr. Key, that in addition to that original loan that you haven't been paid, Stonetown has actually advanced more money to the receiver to operate the utility, hasn't it?
Yes, it has.
And why?
Well, obviously we made this loan. Former managers of this company, left Randy with quite a bit of a mess. So when Randy took over the system, he was quite understaffed. He had 2 employees. He had a lot of outstanding payables. And when you don't have the money to hire people or the money to pay your sales taxes or the money to operate the system, it's hard to get going. So at Randy's request, we advanced some funds to give him some operating capital to begin to do those things, to begin, to work with the city of Farmington, to begin making payments there, to structure the deal that he was paying the additional 10% on a monthly basis for the last few years to catch the bill up in full, to pay the vendors who appropriately began to refuse to give AV Water or sell AV Water parts. So if Randy needed to buy, a water line or a PRV or some other form of equipment to improve the system, he couldn't because those vendors were owed quite a bit of money. So the monies that we advanced to Randy were to help get the system back on its feet once the former management was replaced.
And has Stonetown taken any individual action against the former owners to try to recoup its monies?
We have, no, but I believe that we could. I think we have the right to, but we have not.
Also on page 2 of your testimony, at the bottom of the page, you're still answering the question posed at line 4, explaining your interest. You say, Stonetown is interested in not just receiving payment on the loan, but in helping to improve AV Water's ability to function and provide adequate service to its customers. That's your testimony?
That's correct.
Why?
Well, I think this is a public concern. This is folks getting water. This, the previous owners couldn't go out and get a normal loan, which is part of why our company is involved and why we made this loan. But, obviously we haven't been paid on this facility since 2016. And under Mr. Lewis, we have not received any payments. And having a functioning and well-capitalized utility in this area is important. I mean, I think there are 2,000 taps and probably 6,000 people if there are 3 people in a household. So that's a big deal in my mind.
Are you more optimistic with Mr. Lewis's actions taking as the receiver and the current offer to buy than you have been in the past about getting some repayment?
Yes. I would say I am perhaps most optimistic with the operational improvements that Randy has put in place over the last couple of years. The the system runs now. So bills are getting out, bills are coming in. Abandoning the old treatment plant, which was pre-Randy, while it adds an incremental cost to the system and something that is part of why a rate case is necessary, I think it has alleviated significant water quality concerns on the system. You look back to 2016 when there were oil alerts and they had to flush the system, and there was the Gold King mine spill and they had to build a pumping station. So, following the connection to the city, I believe that a lot of the water quality concerns have been resolved. And like I mentioned, there's an incremental cost for the quality of the water, but that is, that was perhaps, in my mind, the best thing that happened. Subsequent to that, Randy has hired appropriate staff. He's hired a level 3 and a level 4 operator to help oversee and train his more junior folks. That has helped immensely. And I think what 2019 tells us is, despite there were certainly challenges in 2015 and 16. But 2019 tells us that even when it's running pretty efficiently, the company still struggles to pay all of its bills. And I think that is, that's part of the reason that we're here today. And to answer your question even more directly, yes, I think now that the company is operating as it is, and there's the concept of the rate case has been, or the need for a rate increase has been identified, I think that rate increase will set the company up to be more attractive for somebody, or for a more established, capitalized, experienced water operator to come in and purchase it.
So from your perspective then, the amount of this particular rate increase from, like I say, from a finance perspective, where it's actually going to be able to cover its expenses and potentially have some money to put toward its debt service, does that make this rate increase more attractive than a lesser amount?
So I think this one bridges the gap pretty well, because first and foremost, Randy needs money to pay his operating expenses. And the concept of not having cash, or having to use, cash in your bank account to pay your taxes or to hit payroll when you're not generating enough revenue to cover expenses, that's step one. So the 27% gives him, and if I look at the exhibit, gives him the $160,000 in operating deficit, right? And it leaves about $250,000 to pay debt service. So I don't have anything to do with the water rights loan. That's another lien against the company and against those assets. Our loan is a lien against the water company and the water rights, so that you can see that there's going to be a dispute over, who gets paid what at sometime very far in the future. But the 27% creates, if we take the exhibit as what it is, it creates $250,000 to pay interest expense. But to pay full current interest expense, that number would need to be $354,000. So there's still $100,000 $100,000 cash deficit. And that is a dispute that likely I will be having with Randy and the creditor on the water rights, because to pay everybody on their current interest in full, you would need to have that 354. That would be more like a 33 or 34% increase. So I actually think the 27 comes off that a little bit. It says you can cover operating expenses and there's some money to pay debt. And importantly, I think to secure the water rights, because there is a pending foreclosure action on those. And then, I hate to be the, I at least have control over the Stonetown component of the debt. So that I could see a scenario where $150,000 is paid to the water rights holder. The Stonetown continues to take the hit on the rest.
Mm-hmm.
Or we could come up with some kind of agreement with the water rights creditor But long way of saying, even the 27% doesn't make all the creditors in this stack whole. And admittedly, I think the debt on this system is, hopefully it will be restructured under a new purchaser. So I think the 27% ask is, I think it's reasonable. I think it gives Randy what he needs, but it also doesn't fully satisfy creditors, and it doesn't ask for all of it from the ratepayers.
Okay. Okay. All right, sir. That's what I wanted to know from you. I thank you. Ms. Drake, any redirect for your witness?
No, ma'am, no redirect.
Mr. Lewis, anything of Mr. Key's? Keep wanting to give you an S, Mr. Key.
I get that a fair amount. It's okay.
I have nothing. Thank you.
Very well. Ms. Northrup, Mr. Northrup? Nope.
I don't believe I have anything. The only part of his testimony that I was unclear about was when he said that Stonetown doesn't have any involvement with the land portion. I thought that Stonetown owned the land portion. Is that not true?
Mr. Key?
So Stonetown does own some of the land on the system, yes.
Okay. But does that relate to AV Water?
So as our loan was, and backing up a bit, I don't think I misspoke earlier, but our loan was made as part of a bigger transaction. So we are not related to Animas Valley Land and Water Company, but we bought some assets from them and made them this loan in 2014.
So is that when I've lived in the system for 13 years, and my husband grew up in the system for 15 of years or something. So in about 30 years, we've been involved with AV Water. They were used to be the same company, right? And then is that in 14, you guys split the land and the water portion?
That's exactly what happened, yes.
And is it my understanding that all of the debt went with the water and all the assets went with the land? Is that true?
I don't want to misspeak because I don't know. I don't know everything that happened under the seller's control, but when we purchased the assets from them and made them this loan, there was enough money there to pay off all of their previous debt. So our loan came in on the water company and the water rights to restructure their debt. So I don't know if their debt was, I don't know how their previous debt was structured.
I guess the only reason it would concern me is because I've been told with, various homeowners, we discussed things, and they said that the reason AV is valued with so much debt is because it took on the land debt with it. And then when they split, the assets went away and only the debt stayed. Is that
Karen, to my knowledge, that's not.
You can't talk at the same time. Do you know if that's true, Mr. Key?
I don't believe that's true.
Well, you said you restructured or not restructured, but that you offered the original short-term loan, which was supposed to be 18 months. Is that correct?
That's right.
And wasn't that original amount of the loan $5,709,365?
The note was written in that amount, but only 3 million of that was advanced. So AV only ever borrowed 3 million of it.
Okay, so the original loan was for 3 million, And how much is left of your loan?
So this gets into it a little bit, but our principal balance as listed in my testimony is $1,857,000.
Okay,
Now,
plus interest.
oh, we have 3 years of accrued interest that is not considered in that number. That's just the principal amount.
There's a lot of feedback
Okay.
coming from Ms. Northrup. I don't know if she's done answering questions, not.
Ms. Northrup, do you have any further questions of Mr. Key?
No, I guess just to clarify, is there any debt with the land portion left?
So let me try to add a little bit of color to this. So we made this loan, this $3 million loan to AV Water to Animas Valley Land and Water and AV Water. Our collateral was the vacant land on the system, the water system itself, and the water rights. So those 3 things. So we received interest payments through May of 2016, at which point they stopped. So after 8 months of non-payment, we worked through the courts to have Randy appointed to run the system because it wasn't just us who had liens on the system. It was a pretty complicated, messy scenario for other folks.
Yeah.
So in 2018, Stonetown actually foreclosed on the vacant land parcels that were part of the collateral.
Oh,
Stonetown
Okay, that
owns
makes
those now,
um,
and a value was assigned to those vacant land parcels, which is why our principal balance is less than the 3 million initially advanced.
okay. And so who owns the rental then, the rental land?
The rental land is owned by a Stonetown affiliate. Those were the assets initially purchased from AV Water, from Animas Valley Land and Water.
Oh, okay. All right. Thanks for your help, Mr. Key.
Okay. Thank you, Ms. Northrup. Mr. Pedecco, anything from staff?
No, thank you, Madam Hearing Examiner. Thank
Okay.
you.
Very well. Thank you, Mr. Key. You are excused. Ms. Drake, anything further from Stonetown?
Nothing further. Thank you, ma'am.
Thank you. Melissa, we okay? We all right, or you want 5 minutes?
Fine.
You
If
fine?
everybody else is
Okay.
fine with it, keep going.
All right, let's sally forth then. Mr. Pedacco, you have some witnesses.
Yes, I do, Madam Hearing Examiner. If it would please you, I would call Mr. Timothy Martinez to the stand, please.
Very well. Melissa, if you could swear Mr. Martinez, please.
Mr. Martinez, do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. And here's my ID. Let's see if I can get it. I don't
All I
know.
see is a river.
Yeah, it's not coming in. It's my state ID.
That's all right. We're good.
There we go. There we go.
Go ahead, Mr. Pedacco.
Thank you, Madam Hearing Examiner. Mr. Martinez, do you recall preparing some testimony in support of the uncontested comprehensive stipulation that's been filed in this case?
I do.
And have you seen the copy of your testimony that was circulated and provisionally marked as Staff Exhibit 1?
Yes, I have.
Okay. And that testimony was written under your control or direction or supervision, is that correct?
Yes, it was written by me.
Do you have any corrections or changes to make to your testimony today as we sit here?
No, I don't.
And if you were asked the same questions that were posed to you in that testimony today, would your answers be the same as those reflected in Staff Exhibit 1?
Yes, they would.
With that, Madam Hearing Examiner, I would move Staff Exhibit 1, the prepared direct testimony in support of uncontested comprehensive stipulation of Timothy A. Martinez into the record.
Any objection to what's been identified as Mr. Martinez's prepared direct testimony in support of the stipulation? Hearing or seeing no objection, Staff Exhibit 1 is admitted. Mr. Bagatto.
Madam Hearing Examiner, thank you very much for that. And with that, I would tender Mr. Martinez for any cross-examination.
Very well. Mr. Lewis, any questions for Mr. Martinez?
I have none, thank you.
Ms. Northrup, any questions for Mr. Martinez?
No, I don't have any. Thank you, Madam Hearing Examiner.
Okay, very well. Ms. Drake, any questions for Mr. Martinez?
No questions, thank you.
Very well. Good afternoon, Mr. Martinez.
Good afternoon.
How are you doing?
Doing all right.
Doing okay, even though we're
Absolutely.
homeless?
Absolutely. It's a different time. Things are in some ways more difficult. In some ways they're a little easier, but we're making do.
Yeah, like I say, you're in the middle of a river there, so
Yeah.
you know what can I say? You've had over the years, Mr. Martinez, you've had occasion to be familiar with the AV water utility.
My first interaction with this utility was in 2017. Unfortunately for the PRC, I was the employee left in the utilities division, so there was nobody else left to deal with the issues that arose with the water quality, the mine spill and the water quality issues that ensued from that. And so that was my first introduction to the utility, was in approximately 2017, late 2016, early 2017.
And I think probably as you have heard and are aware, I mean, the commission did have a docket open to investigate the water quality issues and other things that were going on with the AV water system at that time, correct?
That's correct.
And when you first became involved, was the AV water, did it still have the two different systems?
It did. I came in to testify in the abandonment of the Harvest Gold system. That's where my interaction with this utility began.
So there actually was some type of abandonment proceeding within the context of that investigation?
Yes, there was. There was an abandonment. The residents of Harvest Gold formed a mutual domestic, and the assets of the utility were transferred over to those folks at no cost. Or $1, I'm sorry, it was for $1. By law, there's supposed to be at least a $1 transaction value.
And do you know what assets those were, Mr. Martinez?
Those were the assets of just Harvest Gold, the pump house, the lines in the ground, and the water rights from the Animas River. The utility plant that was essential for operating that utility, it was essentially what was transferred over.
So it's your understanding that the actual water rights to the Animas River approximately 44.9 acre feet were transferred over with the system too?
That's my understanding. That's what I remember of that case, that everything necessary to operate that utility was transferred over to the mutual domestic. They had similar water quality issues, and they were seeking to connect into the town of Bloomfield in order to get their water. Their facilities were highly contaminated with the gold mine spill. Their filtration system was not working at all. There was a lot of silt and grit within the water lines. The water itself had a foul smell to it. And the water that they were getting was entirely coming from the Animas, and that was filtered in through the system. That system that was not working.
And my understanding, that was approximately 140 taps serving 500 customers. Do you recall that?
That sounds about right.
And the system that they have now with the mutual domestic, is it still a diversion system?
Once the transfer occurred, I'm not sure what they've done since then. The commission no longer had jurisdiction over them. And so what they did after that, I'm not entirely sure. I know that at the time of the transfer, they were looking to connect into Bloomfield system. And Bloomfield, their system relies on well water as well as surface water to provide water service. Their filtration system and treatment system was much better than what Harvest Gold had. But during the mine spill, they were primarily relying on well water, not using surface water just because they couldn't use it. It wasn't safe.
Okay. And also during that time, the commission instituted some fines against Mr. Upenlatz and AV Water, is that correct?
That is correct.
And those weren't paid, were they?
Not to my knowledge, they were not.
And was there some type of agreement that the commission made with regard to those and the transfer of the system? The Harvest Gold system, if you know?
I don't remember if there was. I know that at that point, that was something that was dealt with by OGC, and staff was not directly involved with what fines were collected or whether they were going to court to try to retrieve those fines.
And three, 5, and 6 are the areas of the stipulation that you are dealing with, Mr. Martinez?
I believe so. Section 3 as well.
Section 3 is the repair and replacement charge,
Yes, that is.
correct?
Yes.
And I know in your testimony, you're talking about system improvements. I guess what that charge would be for. And so I guess my question to you is, are you familiar with any other water system, either that the commission regulates or systems that we don't regulate, that has this kind of repair and replacement charge for its water customers?
Up until this case, I had not heard of that. Normally, a charge like this would have been incorporated into a base charge or an access charge. Through the process of mediation, I learned from Ms. Northrup and her dealings with the city of Farmington. The city of Farmington has a charge similar to this R&R charge in their rate structure. And so that was used as a model in developing this charge for AV water. But this was something completely new to the staff, and I'm not aware of any utility having something that is line itemed out that rehabilitates the infrastructure of a utility.
But since you're supporting it, obviously you don't have a problem with it, right?
I don't. I think it's informative to the folks that are customers on this system to know that there is a charge that is going directly into the system to repair and rehabilitate. The system has a number of issues, as has been well documented. It's in need of repair, it's in need of rehabilitation, and these folks at least know that monies are being allocated towards that process with this line item charge.
Well, do you think some of the customers might have an issue with, repairing something that belongs to somebody else?
I think that each customer with this charge will equally be paying into the rehabilitation of the system. Each customer is charged the same amount regardless of what rate tier they're in. So I think everybody will be paying their share into this rehabilitation of the system.
Well, so for example, if I rent a car, I'm going to pay for the gas when I use the car, and I'm going to pay a certain rate to drive the car. But, I'm sure not going to buy somebody tires for the car, am I?
No, you wouldn't. But what I think the best way to differentiate between that is that the main lines through the system will be serving essentially everybody. There's looping within the system. So with that looping, you're pressurizing the line. And so it may not help somebody in the lower section of a system, but it may help somebody in the furthest east portion of the system. It's all interconnected. The water in the lines feed all customers. And so all customers should share in that rehabilitation and replacement cost.
Do you have any concern, Mr. Martinez, in section 5, which is the quarterly status reports and the receivership case? Do you have any concerns that if and when that case comes to a close, that the new owner would come in and raise rates again?
I believe New Mexico Water Services is very much a capable utility. I have worked closely with them in other utility cases. Indian Hills comes to mind. They were a very rundown system who had a lot of issues, and they came in with the plan, and I would fully expect them to come in with a plan in the case before the commission on the sale and abandonment to get approval from the commission for that. I would fully expect them to come in with a plan on how they are going to also continue the rehabilitation of the system and what the impact of that would be on rates. I do think as a large utility for New Mexico, they're our second largest utility, there are some economies of scale. Their parent company is out of California, so they have capital that they can provide to its affiliate here in New Mexico. I think that they will find efficiencies within the system. I think one of the first things they'll come in and do is they will have a meter replacement program. I think they would want to get all meters on a remote read so that they can be read accurately, efficiently, and that's one efficiency I can see with the system.
Aren't those really expensive?
They could be, and that's one of the first things they did in Indian Hills. They came in with a plan. They did increase.
Hang on just a second. Yeah, Melissa?
Thank you. I missed the name of the company that he was just referring to.
New Mexico Water Services.
I'm sorry?
New Mexico Water Services,
Thank you.
when they purchased Indian Hills, they came in with a plan on what was most needed in the system. They addressed meters and they addressed the tank, the water tank, the storage facilities that utility had. Those were their two most pressing issues. They came in, they had some money that they set aside and worked to get the system functioning and operating efficiently and providing reliable service. I don't believe, and I'd have to double check this, but I don't believe they came in for a rate case in the first couple of years. They came in with their plan, the commission approved the plan that they had, and they moved forward from there. We have not had any complaints from any of the customers since that utility has acquired Indian Hills. New Mexico Water Services acquired Indian Hills. Prior to that, there were times where those customers didn't have any water service for a number of days. All of those issues have been remedied. And so I have a lot of confidence in New Mexico Water Services as a utility owner who could come in and run an efficient utility and keep rates as low as possible.
Mr. Martinez, since you've indicated that you first started becoming aware of AV Water, I believe in 2017,
Yes.
correct? And approximately around that period of time is when Mr. Lewis became the receiver over them. Have you worked with Mr. Lewis before?
I had not. This was the first experience working with Mr. Lewis.
And has the commission been getting any consumer complaints about AV Water or its services during this time?
There have not been many since Mr. Lewis has been operating as a receiver of the utility. Prior to his handling and operating of this utility, there were a number of complaints, some formal, some informal. Those are, I believe, in the docket, the 16195, I believe it is. There are a number of comments in that and complaints regarding this utility. Since then, there have been very few.
And the ones that you can recall, do they relate to billing issues or do they relate to quality of water?
Primarily the billing issues. And I think that's why it was important for the interveners to get that provision in section 6 that deals with timely billing, and it ensures that they will be billed at roughly about the same time every month. And so there's no carryover from one month to the next. That's primarily that was the biggest issue.
Okay. And your testimony on page 6, you're answering discussing section 5, the quarterly status in district court receiver case. And on page 6, beginning on line 4, you say, so long as progress is made in the district court case, the signatories agree that the stipulated rate increase should be approved by the commission and put into effect as soon as possible. That's your testimony, sir?
Yes, it is.
What do you mean by so long as progress is made?
Well,
what does that mean?
In the discussion, mediation discussion, we wanted some sort of guarantee that this sale was going to happen, and that obviously isn't possible. And so what we want to see is we want to see progress being made towards this system eventually getting under a qualified utility operator. And we believe New Mexico Water Services is that entity. We also don't want this to be a 1, 2, 3 year process. We'd like for it to happen quickly. And we believe that that's in the best interest of not only Mr. Lewis, but it's also in the best interest of customers to have that stability for once in their utility provider. And so we'd like for this to move forward, and we're hopeful that Mr. Lewis will continue to move this forward in the district court. We're not a party to the proceeding in the district court. It's my understanding, though, that the general counsel is involved in that proceeding. And so we felt that this was an opportunity for us to get something in the stipulation that, requires Mr. Lewis to continue to move this forward and not, as best as he can. He's one party to this, the district court case. And we just wanted to make sure that he knew that that was a priority for us, that we wanted this to move forward.
Okay. You're further discussing section 6 on page 8 of your testimony. Beginning at line 7, you say further, AV Water will consult with the Environment Department and other agencies to develop a policy for flushing hydrants and lines on its system on a regular and systematic basis. That's your testimony?
Yes, it is.
And then you go on to say the commission's utility rules don't provide much guidance on this type of policy, but rules 750.13b3 and 750.14c are two rules staff is aware of that AV Water should incorporate into its policy. Is that correct?
Yes, it is.
What are those two rules say, Mr. Martinez?
I can bring those up. I don't know if you want me to read them verbatim to you, or.
Sure.
Okay, let me get that.
I got to know what they are if you want me to include them.
Okay, 1712, 750.13 B3 is the section dealing with distribution systems. Section 3 is dead ends. And it says there that insofar as practicable, the utility shall design its distribution system so as to avoid dead ends in its mains. Where dead ends are necessary, the utility shall provide a means for flushing the mains. Mains with dead ends shall be flushed as often as necessary to maintain the proper quality of water. And 17.12.750.14c is a section of design and construction. And section C is systems used for fire protection. And that states when fire protection is provided by the utility as a part of the water service, the utility shall not misrepresent its fire protection capabilities.
Okay. And so you believe that rule is applicable to the hydrants?
Yes,
Correct?
I do. And I included 14C in there just because there was discussion of a great deal of sediment in the system. And to the extent that that sediment is clogging up a fire hydrant, I think that they should incorporate something into their rule or their policy that, addresses that until that hydrant is cleared, that it may not deliver the fire protection that it normally would without the obstruction.
Well, do you know whether or not the other water utilities that we regulate have a hydrant flushing policy?
They may have an internal one, not one that needs to be required with the commission. They have a flushing procedure that they do frequently, probably quarterly every year, to ensure that their system is free of debris. It's done through fire hydrants, as would be done with AV Water. That's a standard practice. And AV Water has committed to this policy because of concerns from the interveners in this case that they have sand in their water. And so AV Water has agreed to create a policy in this instance in order to address those concerns.
And you say which utilities are you familiar with that use a quarterly flush policy?
I believe that New Mexico Water Services, EPCOR, some of the larger utilities, they do routine flushing of their system. I'm familiar with one instance where a customer had a concern that his water was full of sediment, and New Mexico Water Service made a point of flushing his system weekly to address that concern until the sediment was cleared. He was at the dead end of the system. So they made every effort to ensure that that system was cleared of debris and sediment.
Okay. And did you approach Mr. Lewis or the other interveners to see if they would in fact agree to incorporate in the policies they're looking at the two rules that you suggested?
I didn't. When I was looking at drafting my testimony, I went and looked at the 750 rules, and I probably should have done this during the discussions that we were having and provided it sooner. And so that was my fault in not getting this information to them. But I thought it was relevant to any proposed policy that AV Water will present to the Environment Department or even to the Commission, that they incorporate these two NMAC rules into that policy. It was informational, I felt, to get them this information so that when drafting their policy, they could incorporate that.
Okay. And then on page 10 of your testimony, you're addressing the question posed at line 17. Does the stipulation as a whole violate any important regulatory principle of practice? And you answer beginning on line 19, to my knowledge, the stipulation as a whole does not violating any regulatory principle or practice. Staff is aware that the large increase could result in rate shocks to some customers. Rate shock is not a good thing, is it, Mr. Martinez?
No, it is not. And it is rare that staff would agree to a percentage increase as proposed in this case. That was a concern for us in the mediation. And so when we looked at the totality of the stipulation and the possibility that this increase could get this utility on better financial ground, which would result in the sale of this utility, we thought that that balanced out the concern on the amount of the increase. And so we were willing to support this increase because of that.
Well, I believe you were here earlier when I was asking Mr. Lewis about rate shock, weren't you?
I was.
And so, for example, I asked questions about that 3,000 gallon residential customer who was going to see a 63% increase in their bill. Did you hear my question on that?
I did.
Don't you think potentially that right now there's 273 customers that could affect? And then if you added in the 233 customers that are the 2,000, they're going to have about a 58.5. So there could be some unhappy customers to get that size of an increase, couldn't there, Mr. Martinez?
I do agree that that is a possibility. Staff was willing to support this increase because we believe that having this new owner in place is going to create efficiencies, and it could very well at some point in time, based on efficiencies that New Mexico Water Services may bring to this utility, it may result in a rate decrease at some point in time. That's something that will be hashed out at some future time. But I am aware that there is a large increase to the lowest tiered customers. And when you go from $1 to the $2, it's a large increase for them. And when we were going through and trying to work through these tiers and how to try to fairly balance these tiers, we didn't find any way around that. They could continue to be subsidized, or we could set the tiers as they should have been set, and try to move forward from there. That was a difficult one. And we had a hard time. We as a staff had a number of meetings trying to figure out how do we address this issue. We knew it would be a concern of yours. We voiced that to the parties, and we try to find a way to balance that out to where, yes, it's going to be a large increase for some of these folks at the lower end, but we believe the end outcome of having a qualified and respected utility running this system will benefit them in the long run.
And in fact, staff has that balancing role to look at the public interest, not only from the perspective of the ratepayer, but also the business interest, doesn't it, Mr. Martinez?
We do. It's a very tough balancing act.
And in fact, perhaps if we would ever get the Attorney General, who I believe has the statutory duty to represent the residential ratepayer, but whom I have never seen in over 2 decades of doing water cases, appear in one of our water cases before, perhaps we might have gotten a different perspective just representing the residential ratepayer, but we don't have that in this case, do we, Mr. Martinez?
No, we don't. And like you, I have never seen the Attorney General intervene in a water case.
In our past stipulation case, we did have the Environment Department. Were they notified or included in negotiations? If you know, Mr. Martinez.
They were not involved in any of the discussions. However, I do know that they were aware of what was going on. And the reason I know that is because the rep for the Environment Department is actually a customer of AV Water. So the gentleman who's in charge of the Farmington area is familiar with what's going on. He has inspected this utility as well. And so I've had discussions with him, not only about this utility, but about another utility up in the Farmington area. And he is pretty familiar with what is going on. And he believes as well that Mr. Lewis is moving this utility in the right direction.
Well, thank you for that hearsay testimony, Mr. Martinez. Okay, sir, that's all the questions that I had for you. Mr. Bagliacco, any redirect for your witness?
Madam Hearing Examiner, I don't have any redirect to Mr. Martinez, but thank you for asking.
Okay. Mr. Lewis, any questions of Mr. Martinez?
I have none. Thank you very much.
Very well. Ms. Northrup, Mr. Northrup, any questions for Mr. Martinez?
No, I have none. Thank you, Ms. Knapp.
Very well. Ms. Drake, any questions for Mr. Martinez?
No, thank you.
Very well. Mr. Martinez, you are excused. Thank you very much.
Thank you.
Melissa, shall we take a brief recess?
Sure.
Okay.
5 minutes.
5 minutes? Okay. I have 3:47. So I guess we can come back at 3:52. We'll take a brief 5-minute recess and come back.
Thank you.
Now, why do you do that? You want I think we're back from our 5-minute recess. Mr. Bracco, you have another witness.
That's correct, Madam Hearing Examiner. I would call Milo Chavez to the stand, please.
Hello there, Mr. Chavez.
Hello.
Melissa, would you swear in Mr. Chavez, please?
Chavez, can you raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good
Mr.
afternoon.
Bracco.
Thank you, Madam Hearing Examiner. Mr. Chavez, do you recall filing some testimony in this case on September 4th, 2020?
Yes, I do.
I believe it was labeled the direct testimony in support of stipulation of Milo J. Chavez. Is that correct?
That is correct.
Chavez, I've provisionally marked your direct testimony as Staff Exhibit 2, and I trust that you have a copy of that in front of you.
Yes, I do.
Does that copy of your testimony filed on September 4th, 2020 appear to be complete and correct?
Yes, it does.
Mr. Chavez, do you have any changes or corrections to make to your pre-filed testimony?
No, I don't.
And Mr. Chavez, finally, if you were asked the same questions today that are posed to you in your pre-filed written testimony, would your answers to those questions still be the same?
Yes.
Well, with that, Madam Hearing Examiner, I would move to admit the direct testimony in support of stipulation of Milo J. Chavez into the evidentiary record, and it's marked as Staff Exhibit 2.
Any objection to what's been identified as Staff Exhibit 2, Mr. Chavez, direct testimony in support of the stipulation? Hearing no objection, Staff Exhibit 2 is admitted. Mr. Bracco.
Madam Hearing Examiner, I would tender Mr. Chavez for cross-examination.
Very well. Mr. Lewis, any questions for Mr. Chavez?
None, thank you.
Very well. Ms. Northrup, any questions for Mr. Chavez?
No, not at this time. Thank you.
Thank you. Ms. Drake, questions for Mr. Chavez?
No, thank you.
Okay. Good afternoon, Mr. Chavez.
Good afternoon, Madam Hearing Examiner.
You have some brief testimony in this case.
As brief as
You
possible,
were not
Madam Hearing
feeling very
Examiner.
wordy, were you?
I'm never very wordy.
And in essence, you say that you are supporting sections 1, 4, and 2. So 1, 2, and 4 all have to do with the revenue increase and the rates. Is that correct?
Yes, that's correct.
And basically, you start out with your testimony on page 2, answering the question posed at line 7, why is staff supporting a 27% increase? By identifying a distinct repair and replacement charge, correct?
That's correct.
Mr. Chavez, you've been with the commission for a period of time. Have you, in the cases you've dealt with, either water or non-water cases, seen such a separate and distinct charge?
Yes.
And tell me about that.
Well, I mean, if you recall on this initial EB Water case, there was a charge in there, and I think it was labeled a, gosh, now I'm drawing a blank, but there were two distinct charges in the bill for AV water. One was for utility increases and the other one was for replacement of infrastructure. And then there's other charges that I've seen in other
But
utilities.
wait, before you go on, those charges were put in by AV Water before it was a public utility, though, correct?
Subject to check. I'll agree with that.
Well, I can tell you that those charges were in when I did the CCN case. So
Okay.
and they came out. So go ahead and tell me where else you've seen them.
So I've seen separate tariffs, for example, on an electric utility where they have a separate tariff for renewable energy charges. And, you know, off the top of my head, I'm not sure if I remember any others, but I'm sure there's others where separate charges for specific types of infrastructure or something that's going into the utility are delineated in the bill.
Well,
So
for
it is
example,
not, this is not the first time.
a renewable energy charge is something that's required by law, isn't it? Isn't it a compliance?
Trying to think if, I'm trying to remember if the statute says that it has to be a separate line item in the bill. I'm not sure about that. It could be, but
Well, that
as
wasn't the
far
point I
as-
was going to make, Mr. Chavez. The point I was making is that the renewable energy charge on the bill is for something that's required of the utility to comply with current law, correct?
that's correct.
And my question to you is, are you aware of any separate utility charge for repair and replacement of infrastructure?
I'm not aware, Madam Herring Examiner, but I do recall in some discussions that it's been a topic of discussion between parties to have something similar. And the reason that personally I don't oppose anything like this is because it is one of the main reasons, quite frankly, that I was able to support this because it enables the staff to track what this money is being used for, and specifically it's for infrastructure. Otherwise, it goes into rate base, and Lord knows what happens or what it's being used for.
Okay, and then further on the bottom of page 2, you say the 27% increase is also supported by staff. With the anticipation this utility will be sold, this increase facilitates the sale. Should this transaction not occur, enough safeguards have been incorporated into this stipulation to protect ratepayers from continuing to pay this increase without the docketing of a rate increase or a rate case. Is that correct?
Yes.
I don't understand the last part of that sentence. Enough safeguards have been incorporated into this stipulation to protect ratepayers from continuing to pay this increase without the docketing of a rate case. What does that mean?
Well, I mean, my understanding of the stipulation, and not being a legal expert, but because periodic reporting of the use of this increase, especially the R&R, we're going to be watching, tracking what these expenditures are used for. And also, we will be tracking and watching what happens in district court to make sure that, because this increase is not only to help the infrastructure of the utility, but also to facilitate the sale. If this doesn't occur, and I don't know what the right amount of time is, but staff believes that if nothing happens by mid-year next year, that we should raise some flags and take a look at this again.
But Mr. Chavez, if the commission were to approve this rate increase, you don't think the commission has the authority in the stipulation to take the rate increase back, do you?
I think we have the ability as staff to raise an inquiry. I don't know what the legal term would be, but to say, hey, look, we were led to believe this was to be done. And it's the only reason we agreed to it. The only reason. It's because this system must be sold to a qualified water operator. I've been working on this case, Madam Hearing Examiner, with AV Water for years. And I feel for the customers, and we need to get something done and get the qualified operator running the system. And this was, to me, the only avenue that I could see this happening. Otherwise, I think this continues forever.
You indicated on your testimony on page 3 that that staff insisted the proposed tier structure of volumetric rates must be inclining blocks, thereby promoting a positive price signal regarding conservation, correct?
That's correct.
But in fact, as I pointed out earlier today, some of the commodity rates are decreasing from what's currently being charged, correct?
According to what you pointed out, yes. And if I missed that, then that's my fault. I was more concerned with the R&R, the 27%, or the 73% of the R&R. 73% of the 27% being the R&R, and that at some point, hopefully it's New Mexico Water or whoever it is, comes in with the sale and abandonment, we take another close look at everything that we've been looking at as far as rates, and if those rates are decreasing, then I apologize for not catching that.
You've heard some of my questioning earlier today, Mr. Chavez, and since you're the rate design witness, don't you think potentially the 63% or so that low use customer increase that low use customer is going to get, don't you think it's going to cause some rate shock?
Absolutely, I do, and I personally agonized over that, and I've always been a proponent of, you have to do, as we say in the business, gradualism. But I think this situation is unique in that we need, staff needs to find a path whereby this utility finally gets taken over by a qualified water operator, and the customers get the service and the water quality and everything they deserve. And I thought this was in my 20-some years of doing this, this was the only way that we could get there.
Mr. Chavez, you've heard me today ask Mr. Lewis about the numbers that in percentage increases and the average number of that average customer in each customer group.
Yes.
And Mr. Lewis used for the residential customer, used a 4,976 gallons as the average usage. And I noticed in your testimony on page 3, at line 10, you say the current average residential customer uses 5,058 gallons per month. Do you know
Yes.
why your number is different than Mr. Lewis's number?
My numbers come from some emails that we exchanged back and forth, and they very well could have changed. And so, I mean, I really don't know why mine is different from Mr. Lewis, other than maybe they retweaked the numbers and to come up with an average gallons per month. But this was based off an email that we staff received from Mr. Lewis.
Okay. Also, Mr. Chavez, you've heard me make inquiry here today about the information on the other charges being proposed in this case. To the best of your knowledge, was that addressed in the stipulation?
To the best of my knowledge, I don't recall. All I remember is that it was the assumption on my part anyway, that those charges would all be at 27% across the board. But I don't recall, now that I'm thinking about it, where I saw it or heard it, and if it was in the STIP or not.
Well, again, I know you're in your testimony, when you talk about the 27% increase, you're talking about the R&R, and then you're talking about the the rate design for the, for customer and volumetric, but you don't specifically address those, do you? The other charges?
No, I do not.
Okay. Or any impact on the total revenue requirement?
No,
Correct.
I do not. That's correct.
Okay, very well. Thank you, Mr. Chavez. Mr. Blanco.
Madam Hearing Examiner, I do have a couple questions for Mr. Chavez on redirect, if you'll permit me.
Very well. Go ahead, sir.
Mr. Chavez, do you recall Madam Hearing Examiner's question about the 27% increase and the possibility of low use rate shock as a consequence of that?
Yes, I do.
And notwithstanding the concern that you might have in regard to rate shock, do you still have the opinion that what has been put together in this case in terms of this stipulation is still in the public interest?
Yes, I do.
And that position that it's still in the public interest, is that informed at all by the history of AV Water as a utility?
That is correct.
And prospectively speaking, the reasons that you articulate in support of the 27% increase include the possibility of a sale to a capable utility, is that correct?
That's correct.
So on the balance, and notwithstanding the possibility of a rate shock situation, and given the particular circumstances of this case, your position then is still in the public interest.
That is correct.
Thank you, Mr. Chavez. That's all I have, Madam Hearing Examiner. Thank you very much.
Thank you, Mr. Padacco. Mr. Lewis, any questions for Mr. Chavez?
I have none for him. Thank you.
Very well. Mr. or Ms. Northrup, any questions for Mr. Chavez?
I don't. Thank you, Madam Hearing Examiner.
Very well. Ms. Drake, any questions?
No, thank you.
Mr. Chavez, you've dealt with New Mexico Water Services Company before?
No, I have not.
No, really? Okay,
I don't believe so.
okay. All right, sir. Thank you. You're excused.
Thank you.
Mr. Padacco, you have another witness.
Madam Hearing Examiner, I have one more witness, and that would be Gabriella Dashino, whom I would call to the stand now.
Very well. And Miss Dashino, is there any way to get some light on your face?
I will relocate.
You are dark. I can't. Oh, there you go. Okay, I can sort of see.
There we go.
All
Better?
right. Yeah.
Okay.
You know, some people believe credibility purposes, we need to actually see that face and see, the expressions you're making. And, okay. Little better, little dark on the left side, but.
I don't know. The lighting in my house is hard to gauge here. But with the
Okay.
direct sunlight hitting the computer, it just makes me darker. So it's hard to.
Okay. Melissa, would you please swear the witness?
Absolutely. Can you raise your right hand, ma'am? You solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Mr. Blacko,
Yes, thank you, Madam Hearing Examiner. Good afternoon, Ms. Dashino. How are you today?
I'm good. Thank you.
I'll bet you have a copy of something that's labeled prepared a direct testimony of Gabriella Dashino in front of you. Is that correct?
That is correct.
And that's the testimony that you filed on September 4th, 2020 in this case. Is that correct?
That is correct.
I'll represent to you that I provisionally marked this document as Staff Exhibit 3, and I'd like you to take a moment and just flip through it and make sure that it is a complete and accurate copy of what you filed in the record on September 4th, 2020.
It is.
Ms. Dashino, as we sit here today in cyberspace, do you have any corrections or changes to make to this testimony?
I do not.
And if you were asked the same questions today as the ones posed in your pre-filed testimony, would your answers change at all, or would they still be the same?
It would still be the same.
Thank you, Ms. Dashino. With that, Madam Hearing Examiner, I would move to admit the prepared direct testimony of Gabriella Dashino into the evidentiary record. And as I said before, it's been marked as Staff Exhibit 3.
Ms. Dashino, I have a question on page 2 of your testimony. The question posed at line 1 says, has staff reviewed AV Water's statement of revenue and expenses? And then you have at line 2, Exhibit A. Is that correct?
That's correct.
And is the Exhibit A you're referring to an exhibit?
That is the exhibit that was in the stipulation.
So
I
Exhibit A
believe.
is a stipulation exhibit. It's not an exhibit to your testimony.
That's correct.
Very well. With that clarification, is there any objection to what has been identified as Ms. Dashno's direct testimony in support of the stipulation? Hearing no objection, staff exhibit 3 is admitted. Mr. Baraco.
Madam Hearing Examiner, thank you for the admission of Ms. Dashno's testimony. And with that, I would tender Ms. Dashno for cross-examination.
Very well. Mr. Lewis, any questions of Ms. Dashno?
I have none. Thank you very much.
Very well. Ms. Northrup, any questions for Ms. Dashno?
I don't have any questions. Thank you, Madam Hearing Examiner.
Thank you. Ms. Drake, questions for Ms. Dashno?
I just had one question for her, if I could.
Okay.
Ms. Dashno, following up on the hearing examiner's question, on that same page 2 of your testimony on lines 4 through 6, you ask a similar question about Exhibit B. And just for clarity, are you referring to Exhibit B to the stipulation there?
Yes, I am.
Okay, thank you. That's all I had, ma'am.
Thanks for filling that in for me, Ms. Drake. I appreciate that. Good afternoon, Ms. Dashno.
Good afternoon, Madam Hearing Examiner.
You also were brief here in your testimony, correct?
Yes, I was.
And I'm just wondering, in addition to reviewing the stipulation exhibits, did you review anything else in this record?
I reviewed it all, but I'm only testifying to the revenue increase.
Okay, yeah, I figured you probably did, but I need to ask that. I mean, my assumption is that you reviewed the application, correct?
That's correct.
And all the schedules that were included in the application?
I reviewed, yes, all the schedules, and I do recall there was a variance granted in April, I believe, to where they didn't have to submit the backup regarding these expenses and revenues that are on Exhibit A.
Okay, and you also reviewed the corrected schedules that were contained in Mr. Lewis's errata testimony?
I did.
And did staff conduct discovery in this case?
I don't recall doing formal discovery.
Okay. But did you review any other documents during the pendency? Don't violate mediation secret talk or anything, but you reviewed other or had other conversations concerning documentation relating to the operation of AV Water?
Yes, we did have communications about that.
And can you answer my question about whether or not the revenue and expenses that were contained, specifically as you're testifying to exhibits A and B, do they address my question about what are the parties proposing to do on the other rates?
I'm sorry, could you repeat that?
Sure. You've been listening today, and you know I have a concern about what the parties are asking the commission to do with regard to the rates in addition to the 3 customer rates that AV Water charges.
Yes.
Can you help me out on that?
So you're regarding the residential, the multifamily, and the commercial rates? Is that what
No,
you're...
the other ones that I can't find any testimony or any documents on in the stipulation.
Okay.
You know what happened to them?
No, I cannot elaborate on that for you.
Okay. Do you know whether or not they were included in the revenue calculation in?
I believe they were. Our agreement was a 27% increase overall. So that would affect all customers, and that includes that R&R charge for all customers.
Okay. But you can't point me to any place in the stipulation that specifically says, and for the rest of the rates, the meter charge and the insufficient check charge and et cetera, that's going to point me to any documentation on that.
No, I cannot.
Okay.
Oh.
In testifying about your review of the revenue and expenses, do you believe that the expenses as set forth by the company are reasonable?
I do.
Why?
With regards of what I had to review, I did do some informal questioning about some of the expenses that weren't very clear to me, and I got my questions answered. So yes, I do believe that they are reasonable.
I mean, do you think they're consistent with a similarly situated type of utility?
I have only worked with EPCOR as another water utility. So being the large scale of difference, I can't really say so much as to what to compare them to, but let's take for instance the office expense here. I believe that's an annual expense for rent, and being it's an office structure, I find that to be around what the cost of an office building may cost to rent a space in. And let's see, what else did we have here? The accounting charge, and I believe you got that answered by Mr. Lewis, that is for outside accounting. I mean, I did have some of the same questions you had that you were asking Mr. Lewis, and without having any additional backup and a variance being granted to having the support behind these, I had to base my judgment on good faith.
Okay.
What?
So then basically you're accepting Mr. Lewis's testimony that given the nature of his relationship with the utility and his necessity to try to get them out of the dire straits that they were in, that he's having to outsource some of these things which are more expensive than a publicly owned utility that say was run efficiently might have some economies of scale that he's not privy to.
That is correct.
That's a reasonable explanation to you.
Yes. As I mentioned, without having full schedule to review, I am having to rely on the good faith that Mr. Lewis is confident in this operating and revenue expense statement he provided, and he's not trying to inflate anything to benefit AV Water. That's
Right. And as,
that's the best explanation I can give you.
and as a matter of fact, I mean, he is not even asking for any return
That's correct.
on anything, correct?
That's correct.
And as you've indicated in your testimony on page 3, even at lines 9 and 10, even with an increase of 27%, they're still going to have a negative cash flow, correct?
That is correct.
But looking at it, you know, from sort of the economic and accounting purview, wouldn't it be better to ask for more?
I would have liked to have more, and being that they were granted the variance in April, I didn't believe that we, you know, other than our informal conversations, that we were going to get that provided to us because of the magnitude of time that they expressed in their request for that variance, that they did not have the resources to provide that information in a timely manner.
But no, I meant more because of the negative cash flow. Shouldn't they?
Oh, more money? Oh, more.
Shouldn't they have asked for
From
more
an
money?
accounting standpoint, yes, I would have asked for to at least get me to a 0 operating income. However, I believe in his initial application, he had done so, but when he realized that there was an overcollection and he had to make the adjustment to account for that, you know, we were already a little into the docket, and he stuck with the 27% rate increase because I believe it was going to go up to 33 if he wanted to have a 0 operating income. So accepting the negative operating income was part of his budget in this stipulation, I believe.
Okay. But even at 27%, do you have, do you have any concerns that, that's going to have a negative effect on some of the customers, especially the fixed income and low income customer?
I don't believe so at this point. I mean, it's been discussed today that 27%, the R is majority for that R&R charge. And I can only see that as a benefit to the customers of improving the system. Now, the remaining collections that are in their base charge, it's not that much of an increase, I guess. And I know your big concern today has been that rate shock, but the customers need to improve the system to have good water, I suppose.
Well, for example, I mean, the alternative, if there wasn't a system to provide it, in order to get water, the customer has very little option to, I mean, they'd have to self-provide, correct?
That would be correct.
So they either are going to have to bring in bottled water, or they're going to have to dig a well, right?
That would be correct. And I can't imagine the cost of drilling a well at this day and age. It cost me $10,000 17 years ago. So I imagine that cost has increased substantially.
Okay. So then perhaps when weighed against the alternatives, a 27% rate increase for the purposes that I've heard testimony here today is the best option for the ratepayers at this point.
I believe so. And as mentioned in other testimonies, just having that additional income to facilitate the sale to a utility that's regulated by the PRC. You know, it might offer some comfort to these customers if that sale takes place. And, you know, that was kind of, if you look at section 5 of the stipulation, and I'm not a lawyer by any means, but that's what we were trying to accomplish when we set out to agree to this increase. And we tried to safeguard that R&R charge in a way that I think Tim mentioned it, or it may have been Milo, where we can, as you know, if the sale doesn't go through, we can kind of come back in and look at that and see if that amount of R&R is still reasonable, or, you know, if it can be decreased, or 2 years down the line, you know, suppose they do stay out for 2 years, 2 years down the line, if that charge has generated enough revenue to sufficiently cover the cost of that system, then maybe, you know, it can be reduced. And we weren't trying to put these customers into rate shock. We were trying to determine the best way to provide them service that will be sufficient to last them for a number of years.
Well, and again, I don't want the parties to think that I am trying to intimate that that's what the goal of the parties was. I know that's not what the goal of the parties is in this case. You know, I mean, from what I've heard, I know the parties are trying to come up with the most reasonable situation to achieve an orderly transition. So, but again, I think questions have to always be asked within the context of the regulatory work that we do, knowing the effects not only on the company, but on the ratepayers. So
I agree.
I'll leave that. Anything further you think I need to know, Ms. Dashino?
No, not at this point.
Okay, very well. Mr. Baracco?
Madam Hearing Examiner, I don't think any redirects serious Dashino.
Okay. Mr. Lewis, any questions finally for Ms. Dashino?
No, I have none.
Okay. Mr. or Ms. Northrup, any questions?
I don't have any questions at this time. Thank you, Madam Hearing Examiner.
Thank you. Ms. Drake?
No questions, thank you.
Okay. Oh, you're excused. Thank you very much for your testimony, Ms. Dashino.
Thank you.
Mr. Baracco, anything further from staff?
That was my whole stable of witnesses, Madam Hearing Examiner. We're all done. Thank you very much. And
okay, very well. Ms. Northrup, you had some information that you thought that I needed to hear, correct?
Yeah. So
Hang on just a second. Wait.
Okay.
You did not file any pre-filed testimony, correct?
I did not. I did not realize I had to.
Well, you don't have to. Is there any objection from any of the parties that I allow intervener Karen Northrup to clarify the record by giving testimony here today? I hear no objection to that. So Ms. Northrup, we can't see you, but if you would raise your right hand. Melissa, can you swear in Ms. Northrup?
Ms. Northrup, do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, very well, thank you. Ms. Northup, tell me what you would like me to know from your perspective as an intervener in this case and as a signatory to the stipulation, and as you have indicated, a customer of AV Water for a period of years, who is also married to a long-term customer of AV Water.
Yes. So when Randy when we first got the 8% increase letters in the mail, we, of course, the homeowners get riled up very easily in this area. So they were obviously angry right away. So we thought, when I talked to Timothy about whether we should protest or not, he recommended that we should, just to try to get a more balanced approach to what was happening, because our rate would elevate, our bills would get out of hand very quickly. So when everybody says that AV Water overcharges on their water rates are too high, the $30 people aren't saying that, right? It's the people that have $70 to $100, $300 bills in the summer. I know people that have $500 bills in the summer, which is outrageous. And it's not because they overuse. I don't think to the extent that the tier is in that same rate in Farmington would be half that. So they just got out of hand too quickly. So I first protested just to get the tier structure changed. And when I went around to people's homes, the primary theme that you heard from everybody was, well, can't the city of Farmington just take us over? And over and over and over, that's what people would say. And it's because city of Farmington rates are more attractive than our structure for sure. And then they wanted the stability of the city of Farmington that they could provide us. But Randy has, and everybody would say that once Randy took over, the system is ran really well. And for the most part, complaints are drastically lower. So after hearing everybody's response of wanting City of Farmington to take over, I tried to, in the best sense I could tell, was that let's model their rate structure, because their rate structure seems to make more sense than ours. So in that, they had an R&R charge, and I was advised by the City of Farmington attorney, she's like, that's the best thing you can do for your system is to get an R&R charge put on your bill. And when I asked Timothy about getting the R&R charge, he's like, I think you guys will have to see a 40% increase to get an R&R charge, which obviously isn't doable for the homeowners. So I just kind of dropped it. But it was Randy and his graciousness that allowed us with that R&R charge. And I think the homeowners are going to be really pleased with it. And it is, like everybody said at this point, it should be a shared cost. And up to this point, the 0 to 3,000 gallon users, I feel for them that they're going to see a larger percentage of increase than the rest of us are. Percentage-wise, it's different, obviously, but dollars-wise, it's the same. So, and until you get to that 10,000 gallon range, that's where it starts to decrease, and then it decreases all the way until I believe 30,000. I'm not at home, so I don't have my spreadsheet with me, but most in that range, it's about a negative 3% to negative 0.5% decrease for those 20,000 gallon range. And then, but if you compare those same rates with the city of Farmington, they're still a good percentage higher than what the city of Farmington pays. So I remember thinking like the city of Farmington bill would have been $75 or something. The new AV Water bill is going to be like $140. So, and I have my spreadsheet at home. I can send it to you if you want it. But we're still, even though they are seeing a decrease, they're still paying quite a bit higher than what the city pays, dollars-wise and percentage-wise.
Okay.
And then it seems like I had a few other things that I wanted to tell you. I think of them and then time marches on. So I don't know. I guess that was my main concern, that the the initial structure that was set up in 2014 was not, those 0 to 3,000 gallon users were only paying $20 after they paid their water, after they paid for the water, right? So it wasn't having to be supplemented by everybody that came above them, because there's a good bulk of the users are the less than 5,000 gallons, right? If
And-
5,000 gallons is average, then 40% of the customers are underneath that range, right?
And Ms. Northrup, have you participated in any utility proceedings before?
No, I have done some work in our area to get natural gas up there, but mainly I'm just a unemployed civil engineer that wants to better my community. And the homeowners up where we live, there's not very much private property for sale in Farmington that's vacant. Actually, Animas Valley has a pretty good monopoly on the market in vacant land and near the city of Farmington. It's not actually in the city of Farmington, but we're within 5 minutes of it. So I think for the most part, everybody feels that they are part of the city because we're so close. And I feel like the rate of water needs to represent that for the area, right? Like the lowest bill in the city of Farmington is $50. So if that's the going rate for water to supply to your home, I feel like that's a fair amount to charge somebody.
Mm-hmm. And so you actually went out and talked to some of your neighbors.
Oh, lots of them, over 200 of them.
And I noticed that at least the email address of one of the other pro se interveners was entitled Animas Valley Water Protesters. Are you familiar if there's a group or not?
That was the group that Kaylee Groth started in 2016 when you had the catastrophe of the Gold King mine spill. And
okay.
So she started that protest site, and she kept the email. She doesn't usually use it anymore. When I get a hold of her, I use her Dino email.
Okay.
So it's the same person that you're speaking to, though. It's Kaylee Groth full time.
And both, so you're familiar with her?
Yes.
And you're familiar
She's the
with
one that headed up all of that catastrophe. And the PRC is very familiar with her, I think, because of how much dealings I had with her then.
And are you familiar with Tiffany Birmingham?
Yes, she's one of the multi-meter users that is paying a multi-meter rate because she has an RV camper attached to her line. So she's not, and nobody's in it, it's vacant. So she doesn't feel like she should have to pay the multi-line rate for just her and her husband.
Uh-huh.
And so that was her primary reason intervening, was to try to get out from underneath that double cost, basically.
And they both signed on the stipulation, correct?
They did. They were they both, I think Randy said he would address Birmingham's issue the best that he could.
Uh-huh.
And Biglee's issue was the billing cycle days.
Uh-huh.
And then the only other issues I heard from people when I was around protesting was that they had sediment in their lines. And I think that's just because they've had such a large breakage history that sediment gets in the lines, right, when there's lots of breaks. So,
Uh-huh.
and then they weren't adequately flushing after those breaks. So, and Randy agreed to adequately flush after breaks and try to improve people's quality of water. Where I live on a cul-de-sac. So my water line is a loop, so I don't get any sediment issues in where I live.
Okay.
And people
are
should
you
know
familiar
too that there's a. Oh, sorry. Go ahead.
Are you familiar with the Haskells? Did you know them?
No, they never responded. I emailed them twice, and they never responded to either email. So I think that Kaylee, where she works at Dino, she gets in touch with lots of people, that come in that area. And I think that she just said, file your motion. And that way, if you need to use it, it's there. And I think
Okay.
that's just what they were doing.
Well, as as somebody who talked to over 200 people, how do you think this how do you think this stipulated
The rate
rate
shock?
structure? Yeah, well, how do you just think that generally it's going to be received by the AV water customers?
I think it'll be like a mix of people, a mix of emotions, like everything. Like I think those people that don't even want to pay $30 are going to be angry. Those
Okay.
people that just want quality of water and they don't care what it costs them will be happy to pay it. I think those people that have a long history of AV and that have been, money's been stolen from the company, right, for lots of years. I think those people will be happy to see an R&R charge, that money is going to be monitored and accounted for, and that their investment isn't going wayside the way it was before. So I think that we'll have and then the people that have, like, all those people that gave up their landscaping when the tiers got so out of hand will potentially get their yards back in order and more to a appealing buyers, right? Because we're in such a state that Farmington economy is down and home sales are a hardship right now. So, and everybody has zero-scaping anyway, where you live in the desert. But at least you can get it up to standard if you're not so worried about every gallon. There's got to be a happy medium, right? Between, that's what they failed to do before. There was no happy medium between conservation and what's the word?
Cost.
Yeah, like
are the customers you talk to generally appreciative of the efforts that Mr. Lewis has made and trying to move the utility in a positive way?
Yes, I think so. I think everybody that's had an involvement in it realizes how much better it is than what it used to be. And the other half of the people have just heard the hearsay of the history and they go with that. You know what I mean? Makes sense. They haven't taken the time to educate themselves to get to the point that we are now.
Do you think that the average AV water customer realizes that that they would be better off if a qualified water utility actually purchased the system?
That's what everybody wants. Overwhelmingly, that's what everybody wants, is to be out from underneath AV. And it's nothing against Randy. I hope he doesn't feel like it's directed towards him, because it's not. It's the history of the AV name that we need to get rid of, because there's just too much negativity with it.
Okay.
So I think everybody was happy to be seen, to be thought out. And that was one of the only stipulations that made me feel better about the 27% when it came around, was that Timothy, at first I really felt defeated, right? Because they go in asking for 8 and then all of a sudden they're asking for 27. And I'm thinking, if I hadn't have protested at all, and I would have saved myself hours of work and only been out 8%, right? So I was pretty defeated after that initial 27% shock. But after Timothy explained that this is the best way to get us sold quickly, and then Randy explained, he's like, you guys have not been making your payments, your interest payments, and they're just building, right? So he's like, if you guys are able to make these interest payments with this new 27% structure, then we can get sold, and those payments can be made with the sale of the company, and then they won't be the homeowner's responsibility anymore. So as of now, we'll have to make them, but as soon as they're sold, as soon as the company's sold, we can dedicate our funds towards improving the system instead of interest payments.
So, anything else you'd like to tell me?
No, I think hopefully that was, I don't know, hopefully it goes well, I guess. Thank you for your help.
Very, very, very well. And I guess I'll go back through and see if anyone has any questions for Ms. Northrup. Mr. Lewis, any questions for Ms. Northrup?
No, but you can see that she's worked very hard as in this process, and we're grateful for her involvement.
Very, very well. Thank you.
Thanks, Randy.
Ms. Drake, any questions for Ms. Northrup?
No, no questions, but I did want to say thank you to her for her participation in this case. It was instrumental and very helpful. And even though she's a civil engineer, she may soon be able to add raid consultant to her resume. Thank you.
Thank you.
And Ms. Northrup, that definitely was a compliment, although you know, I don't know right now if rate consulting is a booming business or not, but or or if you even would want to come back to a proceeding with us, but you know, you're getting high praise. Most of the pro se interveners that we have in the cases, I've not heard have gotten this kind of praise from the other participants.
Well, thank you. Thank you.
Mr. Badacco, any questions for Ms. Northrup?
No questions for Ms. Northrup, but I echo everybody else's sentiments. Thank you for participating in this case, Ms. Northrup.
Very
Thank
very
you.
well. Well,
Madam Hearing Examiner, you might want to note that my name there's only one R. So if that needs to be legal document, if you'll just take out the R, the second R that people are adding.
oh, it's Northup
Yes. Mm-hmm.
and not a rup.
No. Yeah.
Okay. I will make sure that gets changed.
Okay. Thank you.
Melissa, did you hear that? It's Northup.
I did, thank you.
Yeah.
Thank you. And if there's nothing further then, Ms. Northup, that you want to tell me, you are excused. And I believe that is the end of our evidentiary proceeding here today. Unless someone wants to find me another witness or tell me about one. And I think ultimately then that just leaves us with the procedural cleanup for today's hearing, which basically we've already discussed. So I will just briefly put on the record that there are 2 bench requests. The parties have agreed to work on those 2 bench requests together and give me some type of joint response. And please indicate in the joint response whether or not anyone is going to request any type of opportunity to file something in response to the document, or no, everyone's happy with the presentation, and I can just go ahead and admit the 2 exhibits. That's procedural item 1. Procedural item 2 is Ms. Drake brought up a potential proposed finding / proposed certification. And that's fine if the parties want to participate in that. As you all know, I prefer joint, any type of joint pleading, if possible, rather than competing pleadings. And parties are free to do that at their pace. And just for the benefit of the parties who have not participated in this case, and or might be listening in YouTube land, generally the way that this procedure will now work is the transcript will be filed, your bench request responses will be filed, and ultimately what I will issue is what's called a certification of stipulation, whereupon I make the findings and the recommendation for the commission to accept, reject, or in very rare circumstances, offer some type of modification to the stipulation which the parties would have to accept or reject. And then once I've done that, then the parties get the opportunity to file what are called exceptions to the certification of stipulation. And then what happens with that is that the commission takes the certification and any objections to the certification and issues an order. And you have, I don't know why I always forget. I believe you have 10 days after the certification is issued to file any exceptions to the, yes, it's 1.2.20A5B in the procedural rules. 10 days to file any exceptions. And again, then the general counsel's office will issue an order in this case. And if we don't have anything other than, please make sure that you mail the responses in PDF format. If we don't have anything further, and I'm not seeing anybody indicate that there is, I want to thank you all for your participation here today. Melissa, good to see you. Thank you for sticking with us all day. Went a bit longer, but I somehow think that these Zoom proceedings are taking a bit longer, perhaps. Or maybe I just missed seeing everybody and felt like talking more today. I don't know, but thank you all. And if
Madam
I-
Hearing Examiner, if I'm sorry, if I could just check with Ms. Goodson about when she thinks the transcript might be available.
and I can't remember, Melissa, what the contract is. Is it 10 days or is it whenever?
It's 10 business days.
Okay.
So, I'll of course get it out as soon as possible before that if I possibly can. I would
Okay.
look for it before 10 days, but I can't give you an exact answer right now unless you want to order it by a certain day.
Okay.
Excited.
10 business days, it looks like that's what we're operating on. To be on the lookout. You all can be working on your responses, I guess, prior to that time. Okay,
Thank you.
good. All right, again, thank you all. And unless we have something else, hope you have a great evening.
It's hearing examiner.
Miss Northrop.
Thank you.
Northrop.
Yes.
Yes.
No,
Oh, no, I don't have
that's-
anything. I was just saying thank you.
Oh, okay, great. Okay, Anna, do I need something?
Okay, yeah, so let's see if you can see if we're gonna just end the meeting right now. On your left upper side of the screen, you should have a live on YouTube screen. I don't see here a button that ends up the streaming. Can you check on your side, see if that's the way it's supposed to be done?
Yeah, I actually have that little thing.
And
I
and
can,
then drop down menu, does it have an option end streaming?
yes,
Okay, that's the way to end it, and then you can close the
then I
Zoom
can
meeting.
close the Zoom. Okay.
Mhm.
Excellent. Okay. Well, again, thank you all. Have a great evening. And until I see you again, thank you all very much.
Thank you.
Goodbye.
Thank you, Melissa.
Thank you.